That's great. Thank you, Nafis. So today we're going to talk about intellectual property. Before we get into our presentation, I'm just going to put up one of our other materials that we share with YSpace and Innovation York. And we have actually a partnership with a lot of different organizations through York and YSpace Venture Lab. And what I wanted to do is just show the range of services that we do provide. Today, we're going to talk largely about the core IP services, trademarks, patents, designs, a little bit about copyright. But our firm, in general, the intellectual property space covers a lot more. And since we prepared this brochure, we've actually started a COVID-19 practice. So what we'll do is we'll make this available to Nafis, and this goes through the variety of different areas. We brag a little bit about our firms and ourselves, but mostly we talk about the different areas of technology that we deal with and the different business areas, different enforcement options, and so on. So we'll make this product, this material available through Nafis, and you can at any time contact either one of us. So with that, I'm going to put the presentation back up. And so today, we'll talk a little bit about the two of us and our practice, the core types of IP rights, and how to navigate it as a landscape. So today I'm proud to present this. I think this is actually the first presentation I've done with Reshika since she became a partner in the firm earlier this year. So happy to do it. We've done dozens of presentations, but this is the first one that we've done as partners. So I'm very pleased about that. My practice is largely related to developing and enforcing, licensing intellectual property rights in a broad range of technologies. My background is electrical and computer engineering, but I do as much in mechanical and in other technologies as I do in the high-tech space now. The last couple of years, doing a lot of enforcement and U.S. litigation for Canadian clients as well, both as defendants and plaintiffs, to see what we can do to monetize rights and also to defend our clients when they have accusations. So Reshika, I'll turn it over to you for a minute to talk about your practice.
Absolutely. Thanks, Bhupinder. And yes, thank you for acknowledging. It's the first time we're presenting together since I became a partner, but I've been on mat leave, so it hasn't hit me yet. But like Bhupinder, I'm an engineer by background, and it feels like a lifetime ago that I went to engineering school. Having said that, my practice focuses on patents and in particular patent prosecution. And I meet with smart engineers and inventors all day long, trying to understand what their invention is and help them secure protection for their inventions. I've been with the firm for about 8 years now, and I have worked very closely with Bhupinder, mostly focused on high-tech, mechanical, electrical, computer-based inventions. And that's me. Thank you.
Yeah, so the firm, this is a little bit of background stuff, but in terms of technology, we also deal a lot with life sciences. And we have the largest life sciences group in the country, drafting and filing patents for Canadian life sciences companies and dealing with Canadian rights for international companies. So today we'll talk about trademarks, copyright, industrial designs, patents, and trade secrets. And all of these different rights are relevant to every company in to different extents generally. And most of the time when you are talking about a tech company, a startup, they always talk about patents. They have some concept of secrets. But I want to point out as we get started here, all of these things are important. We're going to start with trademarks. And it took me a long time to really understand this because I worked on the patent side of our business. And I've since invested in some tech companies. And as we've grown, it really has come home to me that the most valuable the most valuable IP that a very, very successful company has is usually its brand. And usually it's trademarks. And so we decided to put this one up front, even though it's not usually the topic that you talk to startups about. But let's talk a little bit about how to choose brands and how to protect your position and your reputation and your image in the marketplace. So you can see that this is made up of a lot of different clips and entire parts of different trademarks, and a lot of them are quite recognizable. The reason that we put it up this way is when you look at this and you realize just how many of these you will easily recognize, you can definitely see the power of a brand. And these are just one letter from a lot of marks. So some of them are the whole brand. You see the McDonald's logo. This is a trademark in and of itself. But here in the H&M logo, even that little part is enough for it to be distinctive and identifiable. So one of the key aspects of a trademark is that it distinguishes the source of a product. And what you're trying to do to have a valuable trademark is to create a connection in the mind of consumers between your brand, your trademark, and your company or your products. And generally it's with the products, but as you grow, you get a brand like Google or Facebook or Apple, it's way beyond the individual products. It really just extends to the company per se and its line of products as a whole. And those are truly the most valuable marks. Some of the most valuable business assets are like the Kraft mark or the Apple logo. These are brands that stand for many, many different products, and yet everyone recognizes them immediately, recognizes the suite of products, and more importantly, it allows them as companies to introduce products very easily into the marketplace using the reputation of their brand. So as examples of what you can protect, words and slogans, you've seen that, designs like the U in York University, but you can go further than that. You can also protect the, it doesn't have to be a static image, it can be an animation. It can be how you lay things out, putting Bereskin Parr in the bottom corner over here versus putting it somewhere else. So a lot of companies are very consistent in their branding. And I can see that from my background and from this logo that we're not, as a law firm, super consistent. But if you ask a marketing expert, they will insist that you do that carefully because even that can become a very important part of your brand. A distinguishing guise is effectively the 3D shaping of a product. So if you look at the grille of a Rolls Royce, or if you look at the shaping of certain products, the Coca-Cola bottle, all of those shapes can be protected as distinguishing guises. So to the extent that they're not functional, to the extent that they act more as a trademark in the sense that they allow a person to quickly look at a product and decide who it's from. So if you look at a Coca-Cola bottle versus a Pepsi bottle, you'll instantly know which one is the Coke bottle. The Pepsi bottles tend to have straight sides and be more generic. So you can also protect sounds, holograms in different countries, scents, tastes, textures. In some countries, you can protect colors by themselves. You know, UPS uses "What can brown do for you?" Well, they use that color as a trademark. And increasingly, if you look at UPS trucks, there's more and more just brown paint and less logo on them as they're trying to build up more and more of a reputation in that logo. So the key to selecting trademarks is that you want something that is very distinctive, and at the same time, you want it to be easily associated with your product. So at one extreme, you have words that don't mean anything, like Xerox, which is a completely made-up word. It takes a long time to establish a reputation in made-up words. But once you're successful, they're very unique and distinctive. Using anything like Xerox will immediately attract attention from them and a fairly nasty letter from the legal department. On the other hand, you have something that's very suggestive, like Skip the Dishes. It's pretty hard to protect some brands because they basically tell you what the product is. And so there's a balance between trademarks that are easy for consumers to understand, which are harder to protect because they're less distinctive, and coined terms or words like Apple, where it's a word that everyone knows, but it's used entirely out of context. And over time, it develops a very strong trademark reputation. So the process, and we're going to skip through some of this legalese fairly quickly, but it is useful because most of you are fairly new entrepreneurs. Before you decide on a brand, it is important to make sure that it's something you can use in the long run. You know, if you have a company name or if you have a product name and you have to make a change to that over time, it can be incredibly, incredibly expensive. So what we recommend is that you do at least some basic searching to know, first of all, can you own the .com domain if possible? And that's getting harder and harder, obviously. But .ca, .us, and other domains, and there's so many top-level domains available now. But can you get a proper internet presence for that trademark and that company? Because that's how people will look for you. And then in terms of registration, generally it's something that you need a trademark agent to do for you, but you can do some analysis yourself. And one of the things I tell people about IP all the time is you can do a lot of homework before you contact us. And you can knock out a lot of things, both on the patent side and the trademark side, without spending your money. And then when you come to someone, to get advice, you have a more structured, more meaningful question, and you get better bang for your buck. So typically what you do with a trademark is you search, you can make it simple. Is it on the trademarks register for use with the same kind of product, in which case you are not getting a trademark registration for it, and you definitely shouldn't use it. And then all the way to the other extreme to say, hey, are there words that sound like this mark? You know, can you register Nike for various products? Well, you probably could. I know of a case of a company called Nike that did mutual funds and sold mutual funds just within the mutual fund industry. And Nike was not able to stop them. They ended up buying that trademark from them because they didn't sell shoes, they didn't sell clothes, they didn't sell anything that Nike sold. So you can find marks even if they're famous. Sometimes you can register them, but the analysis that's required is generally pretty deep when it comes to sound-alike or look-alike type trademarks, where an agent can help you assess, well, what risk are you taking by using that kind of trademark. Once you do that, then the next step is generally register, identify your trademark, file an application. So people will use symbols like the TM or the circle with the R in it and so on. These are general guidelines. So you can use the TM or MC in French, whether you have a registration or not. Generally, most people will expect that you only use the R in a circle for registered marks. That's actually not a law, not in Canada anyway, but it can be considered misleading. So there are places where you can get away with using the R in a circle. I would recommend that you only use it for registered trademarks, even though that is not officially a law. It could be seen as misleading as to the scope of trademark rights. If you register and then license, or if you license someone to use a trademark, use a logo like the one at the bottom. It's very important to distinguish the use of a trademark by its owner versus the use of a trademark by a licensee. And as your company grows, you may end up in a position to license your trademarks. So a few more things. Think about trademarks like thermos and Kleenex. And these are words that people use fairly generically. They use them to mean a product. And like I said earlier, the key is that a trademark must distinguish a source of goods. It doesn't distinguish a product itself or a class of products. If you use your trademark in a generic way, and it typically costs a couple $1,000s per country to get a trademark registration, and we recommend very strongly that you look into that. So I'm going to quickly cover copyright. Copyright is generally not a huge issue for most tech product companies. It can be relevant to your websites and your images and so on. If you're a media company, obviously you're creating content, and copyright is a big factor. What you need to be careful about if you're using software is to comply with any open source agreements, comply with any DRM and any other kind of rights that are built into the content that you get online and that you might want to use in your products. And the other thing that you keep in mind is if you have access to any content from a third party, even if you're using it in a fair way, and you'll probably heard of fair use, you cannot use any copyrighted content in a way that embarrasses the original source of the copyrighted work. And when I say the original source, I mean the original author, not necessarily the owner. So those are called moral rights. And when you're licensing in or out, when you're creating copyrights, it's very important to understand what happens to the material, especially if you're licensing it in and the person that created it doesn't like what you're doing with it. You have to make sure that you contract out of the moral rights issue. So for example, if you download a software library and you use it to make a product that the original author doesn't like, they may be able to come after you for moral rights. They do have to meet some standards to do that, but if in your contract with them you had them waive the moral rights, you can protect yourself. Copyrights and code, like often we'll talk to people who say, well, you know, I don't need to patent my technology because it's all software and so it's protected by copyright. In code, copyright only covers literal copying and translation from one programming language to another. It does not protect the functionality. So if I was to look at someone's software, figure out how it works, and then independently create my own software that functions in the exact same way, that is generally considered a safe way to do it. And if you actually break your company up into two teams, one that looks at the competitor product, defines all the functionality that it has, and another team that looks at that functionality, which you can generate in a report, and makes a product that has the same functionality. That is actually a 100% guaranteed way to defeat copyright. You just have to document what you've done very well. And that's called the clean room technique, where the team that created the product did not have access to the original work. And so they were making an independent product without access to the original, even though it had the same functionality. And so you look at things like Google Docs, and I use it all the time. We did, even internally in the firm, we've been playing some games and stuff, and we keep all our scores in Google Docs. And all of those things, I originally create them all in Excel or Word, and then I just upload them to Google Docs, and they're perfectly compatible. And there's nothing Microsoft can do to stop them, as long as Google has independently created those works. So a couple of additional issues about copyright. Authorship, creating a work, and its ownership are distinct. If you're an employee, when you create a work, whether it's software, whether it's a piece of music or a book or an instruction manual, and you're an employee acting in the course of your duties, then that belongs to your employer. And even in that case, if you're an employer, you should have an agreement in place. But if you hire anyone who is not literally an employee, and by that I mean someone who's an employee under the definition of the Employment Act. So that's someone that you pay on a salary, that you deduct, CPP, UI, taxes, and remit that to the government. Then anyone that does not fall tightly within that category is actually entitled to own their own work. So when you hire a consultant to do any software development for you, that consultant will own the copyright in the software unless you have an agreement to the contrary. So when you're hiring offshore companies to do module development, to do, even to clean up, I'd worked with these guys years ago. They took pictures of people and then they cleaned them up. They got clipping paths made by a company in Bangladesh. And so we could take a picture and 30 seconds later have a clipping path for it because the company in Bangladesh was doing it live. In our agreement, we made sure that the resulting product that had the clip around the person and their hair and so on was transferred to us. Otherwise, the company in Bangladesh would have had some rights to the derivative work that they were creating based on the original picture we had taken. So in general, what our advice is, make sure that you're covering all of these things, and the easiest way to do that is just to get advice on them. So the last thing that I'm going to talk about is trade secrets. And a trade secret is something that is confidential within a context, within a business context. And so that does not mean that it can't be known to anybody at all. It's something that has commercial value, and people don't know it within the industry or within the relationship or within the customer base in which you're making commercial use of it. So for example, Coca-Cola, they keep their recipe as a trade secret. Their recipe's online if you really want to find it. It was disclosed decades ago. But they have a system that keeps it secret. And the system is basically, they have two syrups. Those syrups are only combined when you're doing the carbonation step. And the people that make syrup A don't know the contents of syrup B and vice versa. So they're taking commercially reasonable steps to maintain this secret. And within their industry, if somebody was to make use of that secret, if they originally got it from Coca-Cola, and they had an obligation to Coke or to any company related to Coke to keep it secret, then they would be violating Coke's rights in that trade secret. It's essentially a contractual right that they have, but by taking extremely careful and thorough precautions to protect the secret that people generally could figure out if they really wanted to, they can still enforce their rights against infringers who are intentionally misusing the trade secret. If someone independently comes up with the same formula, then Coke can't do anything about that. And that's one of the big differences between trade secrets and patents, which is something that Reshika is going to talk about. So Kentucky Fried Chicken is the same thing. They have their 11 herbs and spices, and they do the same thing. There's no individual person that knows the entire formula. Now, I like to use the KFC example as something that ties back to trademarks. So they have 11 herbs and spices, and they've used that for a long time as a slogan. I found an article a few years ago that I think it was on Twitter. KFC followed 11 people. So it was the 5 Spice Girls and 6 guys named Herb, and said 11 herbs and spices. And that was a really cool, I thought, really innovative way to increase the goodwill in their brand. And you see companies do these sort of crossovers in how they build their brands up. So even though the 11 herbs and spices is a description of their trade secret, it is also a trademark. And it's one that they protect quite aggressively, and they kind of, have some fun with it in that example. So Reshika might get into this in a little more detail, but when is a trade secret a good idea? And there are a lot of things that you can't patent, and she'll talk about that a little bit. There are some things that it doesn't make sense to patent. And sometimes early on in the life of a company, you just had an idea. If I thought of something today, well, it's a secret. I'm the only one that knows it. If I decide to commercialize that with some friends, then a small group of us know it. It's still a secret. So early on in the life of a company, every idea is a secret to some extent. And over time, if as you develop your product, you say, well, it's not so innovative that I can patent it, or alternatively, I don't necessarily want to disclose it to the world by filing a patent application that gets published. And it's something that I could legitimately keep as a trade secret. So a lot of electronics are like this. It's very difficult to reverse engineer them. For example, software or firmware that's implemented in FPGA can be very difficult or impossible to reverse engineer. It may be possible to keep those things as trade secrets. But secrets are very vulnerable to being destroyed. Departing employees who go to competitors often leak trade secrets. If something is independently discovered, if it's reverse engineered by someone that has no obligation to keep it confidential, then you can't stop someone who comes across your secret in that manner. In fact, it's not secret anymore. It may have very little value. If you've been licensing your secret out to people and getting some revenue for it, but the secret becomes disclosed, generally, the licensee no longer has to pay for that aspect or that component of the license. There are some ways to work around that, but they're quite limited. If you literally were licensing a trade secret that becomes public, in the United States and in most other countries, you will lose that revenue stream. And secret uses of technology can't be used to invalidate a patent. If you get sued for patent infringement by someone and you say, well, I've been using that forever, if you were not using it publicly, then you can't use that to invalidate a patent. There are some exceptions in the software space, but by and large, you cannot use a secret to invalidate a patent. So Reshika, do you want to take it from there?
Sounds good. There are just a couple of questions about trademarks and copyright, so you can probably answer them real quickly now. First question is a trademark basically a logo?
So no, it doesn't have to be a logo. So let's think about Google. So the word Google has a meaning. It is a number. It's the number 1 followed by 100 zeros. So it's an existing word that no one ever used for that purpose, and no one knew about that meaning until long after Google started using it. But it's a word, and so the word itself can be registered. And in fact, we didn't get into the details of this because it's a bit arcane and nuts and bolts, but the best registration for a word like that is just the word by itself in capital letters. If you get that registration, then that covers the use of that word in any font, in any shape, in any color, any size, any stylizing. So it can be just a word per se, but then we saw some examples. I'll scroll up to them quickly here. But if you see some of these examples, the McDonald's logo it's not a word. It's just a symbol, basically, right? It's a letter M, I guess, in a stylized kind of way. But if you look at Apple, you have the stylized apple with the bite out of it. So that is a logo, but also this word Apple is registered about 10 different ways. It's registered as a word, it's registered with this style, and it's registered with their more modern styles. So the protection that comes with each one of those registrations does vary. And the more stylized your registration, the more it is more of you register it as an image, you have to provide the image. It can be in color, and then that can actually limit it to that color or to similar colors. The benefit of having those narrower registrations is that they're easier to enforce if someone is doing exactly what you have registered. The challenge, though, is they have narrower scope. And so larger companies like Xerox and Apple that have built a huge brand around this, around their brands, will register many different variations and they'll register them for different products. So for example, Apple initially would have had a registration. In fact, they did have a registration just for computers. In fact, the company was called Apple Computer Inc. for the longest time. And it was only about maybe 15 years ago that they took the word computer out and just became Apple Inc. And they did that because their product line had expanded so much beyond computers per se. So they originally had registrations for computers and eventually would have added laptop and portable computers, and then eventually added iPods and iPads and iPhones and everything, it seems. But so the registrations expand both in terms of the brand and the stylizations that it gets over the years, and in terms of the scope of the products. The other thing was, where did it go? Sorry. And this is a list of different kinds of things. So you see some, like Dell used to do this. Intel had a sound, Dell had a sound. All of those sounds are registered. And if you hear the, the 3-tone Intel sound, it's very distinctive. People know which company you're talking about when you hear that sound. So with McDonald's, if you hear, is it you're loving it or we're loving it or something? I can't remember right now, but they will register that as a slogan. They would register that in terms of its musical harmony. And then they would also register it in terms of basically as the underlying, just the music, and then also the finished work with the words and the music. And they can register all of those things in the US. What's the next question?
So the next question is about copyright. The question is, how about for independent contractor related to copyright? And I'm assuming it has to do with who owns the copyright when you have an independent contractor working with an independent contractor.
Sure. Okay. So if you have a company working with a contractor, if you're a consultant or a contractor and you create a copyrighted work, let's say there's no agreement, and this is a very bad idea, but if let's say you do something and basically you have a handshake that says, I will create this work for you, whether it's a piece of music, so it's very creative, or a copy for advertising, which is creative and kind of has a commercial utilitarian use to it, or software, which is very algorithmic. In any one of those cases, depending on the agreement that you have, you will turn over the work to the person that is paying for it, and they will have a right to use it. Typically, their right to use it will be limited to the purpose for which they had you create it. So it might be for advertising, it might be for their user manual, it might be just to run the code and build it into their product. But the actual ownership and the copyright will stay with the consultant. And if the company that bought it from you creates derivative works, so for example, if they take your music or they take your image that you've created and modify it to some extent, you probably have an infringement claim against them, even though they paid you to create it. So it's very important as a company hiring a contractor to make sure that you include an assignment clause so you have complete ownership of the copyright so that you can take it to someone else to modify it or modify it internally or use it for any other purpose other than the one for which you had it created. And I can give you I'll do a couple of quick examples. So we worked on a case a long time ago when I was an articling student, and it was, I think her name was Robertson versus the Globe and Mail. She was a representative plaintiff in a class action against the Globe, where a number of authors had written articles as freelancers and submitted them to the Globe, and the Globe had published them in paper. And then eventually when the Globe had a website, they put those articles online. And these authors successfully pursued the Globe and won on the basis that they had not authorized their article, their copyrighted material, to be used other than in the newspaper, that the use online was not included in what they had licensed the Globe to do. And so the courts determined that the Globe had to compensate them for that additional use that the Globe had made, or stop doing it and compensate them just for the harm that had been done. So that's one example. The other issue with an assignment is you have to get a moral rights waiver from the author. This doesn't come up all that often, but when it does, it's usually a real problem, because the moral rights that reside in the author can only just be waived. They can't be assigned. And if you don't get it up front when the person's being paid to create the work, you generally have to pay them again to get them to not enforce their moral rights.
There is a question about software and patentability, which I think I'll address when I discuss patents.
Okay.
And you feel free to chime in at that time. And then there is a question about taste, taste marks. So can you explain what it means to trademark taste?
Okay, yeah. So these things are pretty difficult. There are scales that define textures and tastes and scents. And when you look at the registrations, they'll often have a very, what I would call a very artistic description of the taste. You know, like for example, for a wine, they might have a taste, you know, it has hints of rosemary, hints of orange, hints of coffee, and it might even have a sequential aspect to it too. It starts in this manner, it finishes in this manner. The definition of the trademark can be quite difficult, and often it's set out in that sort of artistic manner, but the real test is whether you get the product and you have an expert taste it, and then taste the product that is accused of infringing, and the expert might say that they are the same or that they're so close that there's an infringement. And so there are not a lot of taste registrations out there. I'm actually not aware of a taste registration being enforced, but there certainly are scent and other sound registrations that have been enforced. So these things can be pretty hard to define. And usually it just comes back to, well, you know, go get that bottle of wine or go get that product, and I literally compare them. And so a lot of the times these things are done, these kinds of lawsuits would be brought really as tools in the battle between competitive companies. Even the company bringing the case may not be certain about the outcome, but they use it in order to negotiate whatever they need, whether it's to get a license, whether it's to get the other company to stop, or whether it's to get some other advantage in business. And so I've been involved in a few cases over the years where the case was brought against our client. So Reshika and I usually represent the innovative company. We generally don't represent infringers because of the nature of the work we do, but sometimes somebody will come after our clients, and their purpose isn't really to stop them from selling the product that they're accusing of infringing. It's to deal with some other business problem between the two companies. So quite often, these sort of weaker registrations or more creative registrations fall into that category. It's not clear there's going to be an infringement finding, but it does throw a wrinkle into the balance. And lawsuits are expensive, so people will often pay attention to these things. So same with textures and softness. So there's no universal scale for softness. I've actually literally had to deal with patents that say, you know, a guy will run his hand over the material and give you a number. And that guy's dead because he was 80 years old when he got the patent. And this, I'm not kidding, this actually happened. There was a Japanese patent like this that we had to deal with once. And that patent is useless. And if you can describe the softness or the texture in a manner that someone can understand what they cannot do, you might be able to get a registration for the trademark, but these can be pretty hard to enforce.
Okay, and one last question is, if I get a new grad designer to do some preliminary designs for my company pro bono, should I try to get a contract or ownership rights document in place?
Yeah, absolutely, you should. Because if they're doing it pro bono, they're clearly not an employee, and so we already talked about contractors. And so that person will own a lot of the rights. They may own the invention rights, so they're entitled to get patents. They may own any copyright. To the extent that it is a trademark, that's not so clear. Usually the person using the mark ends up with the trademark rights. And if they file a patent application, that also isn't quite so clear. But if you have a contract, then you can clarify. It's the bottom line. So you don't want to be in a situation where you're dealing with a company or dealing with a person who, long after you have created value in something, takes the position that they're entitled to share in that value. And that happens a lot. You know, a lot of companies break up over disagreements about who should get what. And even though you might be friends when you start, if you don't set down the ownership and, you know, how the dividends will be divided, and if the company is sold, who gets to control that transaction? Who gets the proceeds of the transaction? Once a lot of money's on the table, the closest friendships can be tested.
I think there are a couple of follow-up questions about the same topic. Maybe we will take a pause on the questions now and continue with the other two types of IP rights that I'm going to cover. And then if there are more follow-up questions, well, feel free to keep them coming. And we'll address them after I get a chance to talk about a couple other things I like and I'm passionate about. So these are two types of IP protection that I'll be covering today, and they are usually used to cover or protect your inventions, but different aspects of your inventions. Now, first one is industrial design, and the second IP right I'll be covering are patents. Industrial designs really concern themselves with how your invention or your product really looks. How does it look and feel? What are the aesthetic features of it? Industrial designs do not concern themselves with how your invention works or how the product works or what the underlying functionality is. For that, you have patents. So it's a very important distinction. In fact, the Industrial Designs Act, which governs the industrial design regime in Canada, it even uses the phrase that what you can protect using industrial design is unique shapes and configuration or pattern or ornamentation in a finished article that appeals to and are judged solely by the eye. So it gives you an idea that it's really about what you can see and feel. It's more for the physical appearance of things. In the past, or traditionally, industrial designs were commonly used to protect unique shapes of furniture or luggage. A lot of luggage companies, suitcase designs and things like that have filed for industrial design protection in the past. But lately, you'll notice a lot of consumer goods are being protected using industrial design. So Bhupinder, if you go to, thank you, next slide, there is that, Apple phone. The shape of that phone has been protected using industrial design. Icons, user interfaces are commonly protected with industrial designs. Also, if you're innovating in the fashion industry or you have neat clothing articles or jewelry shapes or perfume bottles, industrial designs are good candidate or are a good way to protect those creations. Industrial designs have to be registered. So to get protection in patents and industrial design, you have to actively register your design, and also you have to register them in the country where you are seeking protection. So these rights are national rights. If you want protection in US, Canada, Europe, you're going to have to file an industrial design application in each one of those countries. An examiner in each one of those countries is going to examine your application for newness, uniqueness, and non-functionality. And if they're satisfied that your application meets those criteria, then you will be granted a design protection. Industrial design is also known as design patents in US and some countries, but they are different from utility patents, which we'll cover shortly. What this really gets you is a right, an industrial design protection gets you a right to exclude others who are trying to make, sell, or import an article which has a design that is either similar or substantially similar to your registered design. Okay. And that's really all I want to talk about industrial designs. Feel free to post questions if you have any. But let's move on to the other way to protect your inventions, which is patents. Patents, as I kind of mentioned before, they protect the underlying structural and or functional aspects of your invention. How or what your product looks like is not a concern for patents. It's really about how things work, what are the different ingredients or different components that are coming together, how are they interacting, what are the inputs, what are the outputs. Those are things that you're going to protect using patents. Patent system is based on a bargain theory, which basically means that in exchange for you, the inventors, enabling disclosure of how your invention works, the government has agreed to give you 20 years of monopoly, provided they're satisfied that you deserve a patent, and we'll talk about that briefly. But that there's that exchange that needs to take place. And the idea is that once your patent expires 20 years down the road, a skilled person should be able to pick up your patent and be able to recreate the invention that you are trying to claim in your patent application. Now, patents are what we call negative rights, or they're really rights to exclude others or your competition from making, using, selling, importing your invention. Patents by themselves do not really give you the right to practice your own invention. And we're going to be doing an exercise towards the end of our talk today, and that will make this point, hopefully make it clear. Patents, one of the questions we often get from our startups or new companies is whether they should bother with a patent, or can they just keep their invention a trade secret, and why bother with with patents that to be honest are expensive and they take a long time to get registered. And really this is something Bhupinder kind of touched on when he mentioned trade secret and the shortcomings of trade secrets. So if you're trying to protect something by keeping it a secret, obviously once the cat is out of the bag, it's too late. Your invention will be out there. And also if somebody else, like your competitors, reverse engineer your product, or they do a black box testing and somehow figure out how your invention really works, then there's nothing preventing them from getting a patent of their own on that invention, which can then prevent you from practicing your invention that you haven't gotten a patent for. And another scenario is if the competitors are able to figure out how your invention works, and then they improve upon it and they get an improvement patent, then for you to practice any improvements over your product, you're going to have to get a license from the other guy, and it's not going to be favorable towards you. So if you have something that is patentable or patent eligible, it's worth considering getting a patent for those inventions. And just like industrial design, patents need to be registered. You have to also register them in each one of the countries where you are seeking protection. And what interestingly ends up happening is if you are looking for protection for your invention in, say, US, Canada, and Europe, your scope of monopoly that you will be entitled to may differ from one country to another, because the patent rights are really being dealt with, the laws and the acts and the regulations of each country independently. So you could have different scope of protection in different countries. Next slide, Bhupinder. Thank you. So here we're just going to give you a quick overview of what the patent process looks like. Typically, it starts with, again, you, the inventor, coming to talk to a patent agent or a patent lawyer and describing your invention to them. Oftentimes, the discussion starts at one place where you think, the inventor thinks that ABC is their invention. And as we probe them more, get more information, turns out that there might be, this other area of inventiveness that they didn't think about. So there's a lot of patent mining or invention mining that takes place at this stage. Next so once you described your invention, it's typically followed by a quick patentability search, and it doesn't have to be quick. Sometimes we do comprehensive patentability searches as well, and it all depends on what the appetite for risk is and the budgets and things like that. And what a patentability search gets you is some sort of a sanity check about whether or not your invention is new and inventive and is something that can get a patent or not. Bhupinder mentioned when he was talking about trademarks that there's a lot of homework that you can do before coming to a patent professional. And patentability search is one of those areas where you can do your own searches on Google Patents, online, or any of the free databases that are offered by different patent offices like CIPO, USPTO for US patent offices. And you can get some sort of a sanity check as to how competitive is the field where you're inventing, and whether or not there are any references or disclosures out there that are disclosing your invention exactly or very similarly. But this is sort of an important, even though it's an optional step, it is an important step because it helps us understand how you differ from your other people in your field, from your competition. And once we know that, it is it's followed by preparation of your patent application. And once we know how your differences are from what's in the field, the patent applications are then kind of drafted with those differences in mind, and then an attempt to highlight those differences. We talk about the advantages that those differences that you bring to the table actually provide. This is also the time where we have a discussion about a filing strategy, and I'll touch upon that a little later. But once you have a drafted application, you figure out what countries you want to file in, the next step is examination, and this kicks off sort of the prosecution process. So in examination, each examiner, again, in each one of the countries where you filed for patent protection, they're going to look at your application and they're going to assess it for certain criteria for patentability. And oftentimes they will disagree and reject your application, and the application will come back to you or your patent agent and with those rejections. And then the patent agent will oftentimes respond to those notices by convincing the examiner that yes, whatever the client or the inventor has or has filed is in fact inventive or novel, and it does deserve a patent. And that there could be a couple of iterations in that process, but assuming everything goes well, in 3 to 5 years from filing, everything goes well, you get your patent, then you get what's called a notice of allowance, and you pay your issue fee, and now you have a patent. Everything from when you file a patent application to allowance is what you can, where you can call yourself patent pending. But it's once you have the allowed or issued patent is when you actually have a patent. Okay, next. So here, what I've tried to do in the next few slides is really answer some of the questions we commonly get from our startup folks or people who are not that familiar with the patent process. One of the obvious questions that we get is, what are the patentability requirements? Does my invention really, is it patent eligible even? So the truth is not all inventions are patentable. Specifically, if your invention or if your creation is something in the field of fine arts, patents are probably not the right type of protection for you. But if it's something in the field of science and technology, then you can explore patent protection. Now, to be patentable, your invention must meet a number of criteria. One of them is novelty. What that means is that your invention has to be new in the world. Now, even though, like just a couple of seconds ago, I said that your patent rights are national rights, meaning that you file for protection in the countries where you want protection. So say you only want protection in Canada and you only file a patent application in Canada, even then the criteria for novelty is that your invention has to be new in the world. So a patent examiner is going to look at databases, look at disclosures from around the world to see whether or not your invention is novel. This is not that big of a deal to overcome, as long as you can point to certain differences between your invention and what already exists in the field, you're okay to clear this requirement. The second requirement is of utility, which means that your invention has to be useful, which most inventions are. And once again, it's not that big of a challenge to overcome. Just going back to novelty really quickly, just one word of caution to those who are new to this area is you should know that your own disclosure can destroy the novelty of your invention. So if you publish something in a journal, you're defending your thesis in a conference room, you are presenting your material, putting something online, or your salespeople are going around and talking to customers, if they disclose your invention before you have had a chance to file for patent protection, you can jeopardize your patent rights in some countries. So in some countries like Europe, it may be too late. If you have disclosed your invention, you cannot really get a patent for that invention. You might have to then look for improvements and other things. In some other countries like US and Canada, you have 1 year grace period from the disclosure date. So you kickstart this 1 year period within which you must file for patent protection. Okay, so the third requirement is inventiveness, which means that your invention must be inventive, it must be non-obvious. And this is one of the, I guess, more challenging requirements because it's a very subjective, from my experience, very subjective sort of a requirement. Different examiners can disagree with you or agree with you as to what you are claiming is inventive. They may have different opinions. Now, inventiveness does not mean that your invention has to be, groundbreaking or earth-shattering, because about 90% of the inventions are improvement inventions, and they're 90% of patent applications received by patent offices are for improvements over existing technologies. And as you can imagine, not all improvements are, sort of groundbreaking. To give you a simple example, I often like to use this example of a coffee cup sleeve. So believe it or not, a coffee cup sleeve was a patented technology. There was a patent issued for it, which has now expired. I think it expired over the last 2, 3, 4 years. But that concept of just putting a sleeve around a cup, which holds your hot beverages, was an invention. Now, someone else came along and they did a little bit of innovation in that field, and they came up with the idea of putting 3 dots of glue on the inside of the coffee cup sleeve. And the idea was that when this coffee cup sleeve came into contact with a hot beverage, the glue would melt and it would make for a better grip. And you can hold a coffee cup better, it won't slip. Now, this idea of putting 3 dots of glue on the inside of the sleeve was considered inventive, and a patent was granted for that invention. There's another example that I've heard from some of the senior partners. There is this case where it's about nuclear reactors, but the invention, this application that was filed, was for cleaning fuel rods once in a while, like every couple of years. The fuel rods must be cleaned, was the discovery that kind of got a patent, because back in the day, it wasn't that obvious, I suppose, to do so. Obviously, hindsight, everything seems obvious, but that's not the test. So that's a good thing. And another word of caution here for inventiveness is that I find a lot of the engineers and inventors we meet, they have a tendency to dismiss their own creativity and their own inventiveness. They would come and talk to us and then oftentimes say something like, oh, I've only spent 3 weeks in figuring out the solution, so how can this be inventive? But as I said, the truth is, things could be inventive, even though you think they're not, because you might be too smart. So don't be a judge of whether or not you deserve a patent, especially based on this criteria. Talk to a patent professional and let them help you. And then the last criteria I mentioned here is patentable subject matter. So what that means is this is sort of a gatekeeping requirement, and it lets in certain things and either through certain sections of the Patent Act or through case law has excluded certain things that you cannot get a patent for. So for example, in Canada, higher life forms cannot be patented, or methods of medical treatment cannot be patented. Other exclusions are mere scientific principles or abstract theorems cannot be patented. And so that's what this requirement is, sort of a gatekeeping requirement. There was a question earlier about whether or not computer implemented inventions are patentable or not. And I think that question is, that question comes up a lot. And a short answer to that is there is no case, court case out there that says that you cannot get a patent for your software implemented invention. It is tough to get these kind of inventions through, especially if they're purely software based inventions and they do not integrate with any hardware or device and things like that. But still, they're not excluded from patentable subject matter category, and they could be included. So we can chat more about this later, but some of the ways you can get a software implemented invention through to the patent office, or at least through this gatekeeping requirement, is if your invention has, it integrates software and hardware, or you are working on focused improvements on how to make your computer work better or improve its performance or security or efficiency, then you're okay. If you have a good use case or a specific application of your software, then you're probably okay. Now, on the other hand, if you are just trying to automate something that was being done using pen and paper for a lot of years, then you're probably not going to clear the patentable subject matter category. Okay, so next. Thanks. Okay, so here I want to just talk about a couple of scenarios where even if your invention meets all the criteria of patentability, should you still bother with a patent? And one of the scenarios is where your invention capitalizes on a fad, or it's like a seasonal invention or one season hit kind of thing. The truth is, patent system, from the date you file your application, you're looking at about 2 to 3 to 5 years before you get an issued patent. And obviously there's a lot of money and effort and time involved. But if your fad is going to burn out before that time, then it might not be worth it to get a patent. You might consider other types of IP protection. So here's, if you click next, Bhupinder, there's just a little trinket here, which, you may just want to get design registration for something like this, or you may not want to protect it through any form of IP and just try to be the first one in the market and get a marketed first mover advantage instead. Another scenario, next, thanks. Another scenario where you might not want to bother with a patent is if your scope of protection that's available to you is very narrow. And here, if you press next a couple of times. So one more. Thank you. So here, just by way of a simple example, let's say you're somebody who's innovating in the field of paper clips, and you do a quick prior art search, and you see that the two designs to the left were already known. But you are innovative, and you come up with this square paper clip design on the right. Should you bother with a patent for this narrow embodiment? And the answer is probably no, because really, as we said before, the point of patent is to exclude your competition or exclude others from making, using, selling your invention. Now, if the competition can come up with an alternative design to your invention, they're not going to bother with licensing your invention from you or paying you any kind of royalty. So in situations like that, where your scope of protection is very narrow, you're probably better off not getting a patent. Having said that, there are maybe strategic reasons for which you might want to protect those narrow embodiments. And it's a business call at the end of the day. Next. Thank you. Okay, so next question we're trying to answer is, who can file a patent? This is really a question about inventorship versus ownership of patents. So those two topics, just like we talked in copyright about it, ownership is different than inventorship. Inventor is somebody who comes up with the invention, with the concept of the invention. It could be somebody who who identifies the problem and then, toils to figure out the solution to that problem. But if somebody's just doing providing mere technical support, they're following instructions or doing routine testing, those individuals might not meet the criteria or the threshold of inventors. The first owners of an invention or patent application are the inventors, and then they can assign their patent rights to other people. Oftentimes, if you're working as an employee in a company and you've been hired to invent, then your employment contracts are definitely going to include obligation to assign clauses, which means it is your obligation to assign your patent rights to your employer. Even if that's not the case, you can freely contract in and out of assignments, and you can assign your IP rights to other people, and those people will then be the owners of patents. This topic I think it was a very dull topic for a long time, except very recently, thanks to AI, the topic of inventorship has kind of revived itself. So very recently, the US Patent Office, European Patent Office, and the UK Patent Offices have given out a decision that AI cannot be inventors. To be an inventor, you have to be a legal human person. Now, this decision may be overturned, and we'll see what happens in the future, but as of right now, your AI cannot be an inventor. It has to be a person. Okay, next. Thank you. So another question we often get is about where you should file. This is where filing strategy discussions come up. One thing to mention right off the bat is that there is no such thing as an international patent. There are international patent applications. Some of you may have heard of PCT applications, but they really just give you, they buy you more time and postpone the decision making of which countries to pick and select to a later date. But you still have to pick and select the individual countries where you're seeking protection when you're working the patent regime. Some of the factors you want to consider perhaps to make that decision is where are you selling your products, where your customers are, where are you manufacturing your products, and where do your competitors reside. Another criteria that may be important or factor to consider is how you can block your competitor at the point of manufacture. So let's say you have an invention and you're seeking protection in a bunch of countries, but you leave out Australia. Now, an Australian competitor can sell your invention there without any, without infringement risks because you have no patent there. Having said that, if that Australian competitor is trying to manufacture that invention in, say, China or Israel or somewhere, you might want to file for patent protection in China or Israel and block that competitor at those choke points. Another point I want to mention here is for most of our Canadian, sorry, can you go back? Thanks. For most of our Canadian inventors, US is really a no-brainer. Like US is a very important market, and that's easily the first choice for patent filings. We even have Canadian clients who do not bother with Canada. They only file in US because of the budgets and whatnot. US system is a very robust system. The patent system, the fees are reasonable. And US patents are also expected by investors and they are respected by competition. Next, for Canadian clients, Canada gives you the home field advantage and also gives you very reasonable ways to get a patent through to allowance. In Canada, you can postpone examination for 4 years now, used to be 5 years. And by doing that, you can take advantage of the patent prosecution going on in US or Europe or other countries, and then take the claims that get issued in those countries and bring them to Canada. And oftentimes you won't even face any rejection from the examiner, and you will very cheaply and cost efficiently be able to get a Canadian patent. Okay, we will go on to the next one. So another question we often get is, when can I disclose my invention? Now, this kind of goes back to the point that I made about your own disclosure can destroy the novelty of your invention. So there is no bright line test to this, but I mean, and it's also never too early to talk to a patent attorney, but really you should only disclose your invention when you file for patent protection. And talk to a patent attorney about it. If you have an upcoming disclosure of your of your invention, or if you have, a conference or a showcase or something coming up, it's really the safest thing is to file for patent protection to the extent it's possible. If it's not possible, try and get NDAs signed. Now, NDAs are a very funny thing because they're really only as good as the people signing them. And if somebody signs them and do not honor the NDAs, I mean, you have to go through the courts to enforce those NDAs, right? So probably in some cases, the cheaper way is to get a patent application filed before you go ahead and disclose your invention. Next. Thank you. This is a sort of a self-help slide where I've given you some resources or publicly available free databases where you can do your own due diligence to figure out whether your invention is, novel or inventive or not. You can do quick keyword searches, targeted competitor searches, inventor searches, and things like that on these databases, and try and see if your invention is already out there or not. And with that homework, if you come to a patent agent or a patent lawyer, I think they will really appreciate that and love you for it. So here's some free, resources available. And I believe is there? Oh yeah, okay. So in the next couple of slides, I'm just going to quickly talk about IP and its, benefits and challenges when we're talking to startups about it. Now, it's no secret that IP assets are expensive. They are expensive to obtain, maintain, and enforce. And sorry, I should clarify, it's not all IP assets. Really, we're talking about patents that are expensive. Relatively, trademarks are cheaper. Copyright is, in some cases, if you don't register, it's free of cost. But they could get expensive to maintain and enforce. And enforcement can take a long time, of course. And for some things like patents, the ROI may be very low. About 5% or 10% of the patents ever realize their return, or they get their return on investment. And there is no automatic protection from competition. Even if you have IP rights, you still have to kind of, observe and look around and see who might be infringing your IP rights. Having said that, if you have no IP protection, you really have no legal recourse against infringers. There are many benefits to IP as well. IP gives you edge over competition. It really attracts investors. It helps you unlock capital. IP assets, just like real assets, you can sell, you can mortgage, you can transfer. And if you reach commercial success, then some of your assets like trademarks or patents can give you huge ROIs. And in the next slide, how can you make the most of the IP knowledge that we've given you today is probably to ask yourself how your company or your business or your invention, how is it different from the competition in the eyes of your consumers? Is there something about your product or brand or the quality of your product? And are those differences now important to the success of your business? And if that's the case, then maybe you want to protect those differences and figure out which bucket those differences fall into to get the right kind of protection. Also, make sure your IP strategy lines up with your business goal. It should not just be a checkbox in your business plan. It should really be something that lines up with your business goal. So if your goal is to have an exit 3, 4, 5 years from now, think about who your acquirer will be and what their preferences are. And the last point I want to make is just when you're getting your IP protection, try and future-proof your IP strategy. Think about your competitors, think about their products, think about how your products are going to evolve. Patents take about 3 to 5 years to get, and the monopolies for 20 years. So think down the line and see how you can incorporate some of those ideas in your patent application today. And Bhupinder, do you want to add something to that?
Yeah, so one thing that I will say about this is when you're looking at patents, Reshika listed a few benefits in talking to investors, extracting some funding and so on. One of the key things is, how are you going to compete? Like, what is the moat around your product and your business as a whole? If you have nothing other than a product that can be put into the marketplace and understood by your competitors, and that actually applies to a lot of products. That applies to software that can be easily reverse engineered to pretty much anything that's offered over the internet. And for example, the fidget spinner, there's a woman that invented that thing many years ago, 5 or 6, 7 years ago. She made one for one of her kids. She didn't protect it. It eventually became a very popular product for a fad period. If she had a design for it, she would have been able to extract some value because she would have had a moat around her concept. So where IP fits in for a lot of businesses is as part of that moat. If you have nothing, you're in price competition and you're in a race, right? It's first to market, first mover advantage, and then staying ahead of people. Where IP fits in is to say, well, hey, once you establish a product in the marketplace, you don't actually have to keep moving forward. You can rely on that product and extract higher pricing and higher margins from it. So that's the real value of IP. These are very, very commercial assets. They're not about, they don't have a lot of social value. I think people do sometimes try to extract that social value. And it's funny, in that AI conversation, so I'm involved in a bunch of committees with some international organizations to talk about, well, what should we do about AIs that make inventions? And there's always this issue, well, we name inventors and patents so that we can give them the social benefit of doing that. Well, AIs don't care whether they get named as an inventor. So the benefit that I think you got to focus on is the commercial one. So another point Reshika made, and this ties into this, is engineers tend to have a very dismissive attitude about innovation. Like, well, I did it, so anyone can do it. It's not a question of how easily someone else might do it. The question is, how much investment did you make? If it took a team of 4 people 6 months to do something, that's not obvious. If it's something that solves a long-standing problem, that's not obvious. And if there's a commercial value, if your competitors would want to do it for any reason, that's a reason to get a patent. And so just think about it from very, very commercial, profit-oriented terms when deciding whether to make this investment. So a few questions. Reshika, can you see the questions? I have them open as well. I'll address one. Yeah, okay. Let me just address that last one. Patents and trademarks are definitely 2 completely different legal processes. In all countries, the patent office and the trademark office are different people with different people running them, different examiners, different standards. They're really unconnected to each other. They're in the same building in Canada. In the US, they're also in the same building, even though they're in 10 other buildings. But that's their only connection. There are different statutes, different regulations, and different processes altogether.
Perfect. Then let me start from the top. Okay, if I've started building my product and want to start taking part in pitch competitions, should I have filed patents, gotten copyrights, etc., in place beforehand? I can answer this one. So if you are, I've been to a bunch of pitch competitions and judged a few, and I find that the pitch competitions, the disclosure that happens at that point is pretty high level, because you're kind of focusing on the, the motivation behind your invention or the problems that you're trying to solve. So maybe you don't need a patent. You don't absolutely need a patent. It's not like you go to a pitch competition and now you jeopardize your rights to get a patent. It is recommended if you already have a product that's ready and you have built it. But mind you don't even need to have a prototype of a product to be able to file for patent protection, as long as you believe that your product will work the way you say in an application it will. So if you have the understanding of how this product works, it is definitely, for peace of mind, a great idea to file for patent protection. Now, if another way, like just sort of in my view of thinking about this is commonsensical approach. If a competitor is potentially sitting in that pitch competition and they heard my pitch and they saw my presentation, I think whether I've given enough juice to them that they can now recreate the invention without any more input from me, and that can kind of give you a sanity check and a gauge your or help you make a decision as to whether or not you need a patent. But if your pitch competition deck, slide deck is not an enabling disclosure, you're okay potentially. Okay. Next question is, you mentioned artwork is not patentable, but there are other forms of protection. If I have a personal symbol that uniquely identifies me, I can trademark this, right? Also, I have a phrase in the book. Can it be trademarked? If you want me to do that one? Yeah, I guess it's more copyright and trademark. Yeah, go for it.
Okay, so if you have a symbol that identifies you personally, then that is not a trademark. A trademark identifies the source of a product or a service, and you are not a product or a service. Now, if you provide a product or service, for example, if something really low tech, if you have a cleaning company and the symbol provides a connection between the consumer's understanding of your business and the services that you provide, then yes, then you can register that. But if you just have a personal logo, like a shield or something like that, that's not like a heraldry like icon. then you can register a trademark typically because you just apply for it. And as long as you describe some products and services, the trademarks office kind of lets it go. But in terms of enforcing it, you will have to show some association with a product or service. Typically, you would protect that as copyright material. And so the second part of your question is the same thing. If I have a phrase in a book, if the phrase is identifying the product or service, which could be the book or something that's described in the book, then yes, you could trademark it, but normally you would protect that as a copyright.
Perfect. There's another question. It says, say example, an inventor created a software, neural networks in AI to ride bicycles. Can this type of thing be patentable? It's a very specific scenario that you've given there, Paul. Generally with AI, I mean, some of the questions or concerns that come up are with respect to patentable subject matter, and kind of resonate also with the computer-based software or computer-based inventions that I discussed earlier. When it comes to AI, I mean, you're thinking about, without knowing much about obviously your product here, generally you're thinking about, you know, what are the different, where the novelty occurs. So is there something about acquiring the raw data? Is there a particular new data element that you're considering, which is a non-obvious and new data element that's going into your AI system? Maybe there is some novelty there and you can potentially explore patents. Also, how are you transforming that raw data if that's happening? Are you combining the data in new and innovative ways? Then there could be some, you know, something there that you could get a patent for. So how are you building feature vectors here? And then if you're applying AI to build models and training those models, again, there the novelty could be in you trying to shrink the neural networks and make them fit on your phone, or you're trying to innovate in these well-known AI techniques. Then maybe you have something. And then how are you using the AI models? If there's specific application, for example, here you were talking about bicycles. So if it improves that, you know, there's a particular question you're trying to solve there, and you're using your AI in a specific way to address that question, and the outputs potentially feed into something else. Again, that's a area where novelty might occur, so you may be able to get patent protection. But if you have any specific question about your specific idea, why don't you reach out to one of us, and we'll try and help you with it. Okay, there are a bunch of other questions that have come in. For trademarks, what's the average cost and how long does it take? I heard it takes about 1.5 years, 1.5 years. Is that true? Bhupinder?
Yeah, okay, so it does depend from country to country. One thing we didn't cover a lot about is treaties between countries that allow you to manage timelines and costs. So in the trademark side, if you file an application in any one of most industrial countries, almost all countries, you can expect to pay, for example, in Canada, the typical end-to-end cost from filing to issuance is $2,000 to $3,000. The typical timeline is 12 months or so, and it can be 1.5 years, but it can also be 8 or 9 months. 6 months after you file in Canada, you can file in another country. You don't have to do this within 6 months, but if you do, then you can link those two applications and effectively get the benefit of having the earlier Canadian filing date be deemed to be your US filing date. And the benefit there is that whoever files an application first, and this is true in patents as well, but in trademarks, whoever files first is deemed to have precedence. There are ways around that about when the trademark was used and how distinctive it was and so on. But typically you're looking at a couple of $1,000s to $3,000 per country, 8 months to 16, 18 months from beginning to end, assuming nothing goes wrong. So I just actually settled a case a few days ago where we had filed for a Waterloo-based company, which was owned by one of my good friends, and where we decided to save some money and put off trademark filings for 4 years. And then we eventually did file. And a few months later, somebody else filed a mark, and then they claimed to be using it first. And it cost us 6 figures to deal with that. Had we just filed a couple of years earlier, it would have cost us $2,000. So, and I had invested that company, so that was very painful. So typically, don't wait too long to file your trademark applications. They don't cost very much. They don't take very long. You don't have to file in every country around the world. And we talked about you have to have rights in the countries where you need to. I'm just going to find that slide, but where should I file? This applies to trademarks as well. It's really where you can commercialize. So major jurisdictions. So for trademarks, I typically say Canada, US, definitely. Beyond that, where you're going to do business, where you're going to license things, where you're going to have a real market or a competitor that you could license to or a partner you can license to. So you typically file 5 or 6 or 7 applications. There's a more recent treaty called the Madrid Agreement or Madrid Treaty. Neither one of us is a trademarks expert. We have pretty high level of knowledge. And so under Madrid, you can file one application that effectively covers all countries that are part of that treaty, which is almost all countries. And then you can decide where to enforce later on. You got a couple of years to sort that out.
Perfect.
Couple other questions. Let's see here. My symbol is on all my books and films, apparel. So does it identify me? Is shown on all my work. So I'm going to assume that the work that you're making here is a commercial asset of some type, some sort of creative work, whether you've created books, whether you've created music or something like that, whether you're creating a product and you're marking it as a symbol, that would be a trademark. So because it does identify a product or a service, and you're using that trademark to identify that product or service with its source.
Yep. There's a question.
We have
international. So John Lee says, will international stage patent publish help me passing the country stage patent application approval? I think what you were getting to is the PCT level applications that you file, and perhaps those applications get published. Will that help you pass the country stage patent application approval? If I understand your question correctly, the answer is no. And here's how I understand your question. Indirectly, you're asking me if there is a way to bypass national stage application approval by just filing an international application, and the answer is no. Even you can file an international application called a PCT application. It will get published. It can even get examined, and you can even respond to the international examiner and answer their questions and disapprovals of your application. But you still have to file individually in each one of the countries where you want to get protection for your application. And each one of those examiners in each country where you've now filed your application will examine your application again. The PCT level examination is not binding on any of the countries. And each country examiner is going to examine it based on their laws and regulations. So you're going to have to, again, pick your countries carefully. You're going to have to spend time and money getting your application approved in each one of those countries. Okay. There was a trademark question, or did you want to add something to that, Bhupinder?
No, that's fine. And I'll do the last trademark question there.
Yeah.
So someone says, if I trademarked a business name 2 years ago and another competitor happens to have the same name non-trademarked, then can I go after them? So this question is often resolved on survey evidence. When you file a trademark application, and there's also a question saying, do I need to hire an agent? You don't need to hire an agent. You can file a trademark application on your own. There are some benefits to hiring an agent, but you don't need to, and lots of people successfully file trademark applications on their own. On the patent side, it's pretty much hopeless. There are just too many intricacies. People often get patents issued, and they feel great about doing it, but their patents are usually so narrow. They've usually caved into the examiner so much that they really can't stop their competitors from doing much of anything. But on the trademark side, there's definitely an advantage to hiring a trademark agent, but you can do it on your own. Once you have a registration, you can still lose those rights if your trademark is no longer distinctive of your company. So when you sue someone, there are a few questions that you have to answer. One is the trademark distinctive of your product and your company? And the typical way to do that if you end up in litigation is to have a survey done. There are companies that specialize just in trademark surveys. And what they do is they'll show someone the trademark and they'll ask them whether they connect that in their mind when they're shopping, when they go to the store, when they order stuff online with a particular source. And so, for example, if you look at, I'm going to scroll all the way back up to the top. If you look at some of these trademarks, do you associate that with a particular source? There should be such a faster way to scroll through a presentation, but there is not. Basically, when you look at this logo, right? It's a Telegraph newspaper. Most people don't get that one. Toys R Us, any parent would get that. And what I'm driving to, like Disney, most people would get that. The R in Rolling Stone magazine, many, I don't know. T and Tide, right? So the survey is used to determine whether in the proper market, the market of people to whom these products are sold, your trademark is distinctive. And if it's something that's sold B2B, they will go and do a survey of people that are commercial buyers or in the commercial marketplace. If it's a media company, they go, if you're looking at Disney Plus, is Disney distinctive? Well, the market is almost everybody, but they'll look at the particular accusation that you're making. So the question is hard to answer in the sense that if you have a direct competitor and they don't have a registered trademark, and you can show that your registration is distinctive, then you will probably be able to stop them. But like I said about Kleenex, let's say you start doing a survey and half the people say, well, your company is what they think of, and half the people say it's the other company. That's not distinctive. What's more likely to happen in that case is your trademark will be invalidated and removed from the register. Okay, so Anissa says, my symbol is me. If it identifies me, is not one single product. Yeah, you're better off creating a likeness, like a standard image. So what real estate agents do is they get one image. So there's a person who does real estate work in my neighborhood, and she has used the same image for the last 20 years. So she can use that image as a trademark over time, and certainly everybody around here recognizes her. Everybody around here sells their house through her, even though the guy 2 doors down is a real estate agent. And that's because she has a very good reputation and she's built up her brand in this community. So if your trademark is you, I would say either create an icon or have a particular image or use your name in a stylized way. Names are quite hard to register, but images of yourself and so on are the way to go. If you're saying it's just you and your style as a human being, you're not a trademark.
I think that's about it with the questions.
Okay, so we're going to go on to the next part of this, and let me get this presentation off of you.
Would you mind if I ask you a question, Reshika?
Oh, hi.
Hi,
yes?
it's Ed speaking. So I'm just wondering, like on the patent side, in determining whether or not to move forward or if a product is patentable, using an example of a simple mechanical device, and trying to think of an example of something that's on the market, like I'm not sure if you're familiar with, say, like a brace that's commonly used for tennis elbow, where it's like 2 plates that have a strap and you apply it to your forearm and it puts pressure in a certain position and gives you relief. It's a very simple design, and there's been all sorts of different designs that have come out on the market. Yet, if you look at them, most of them are patented. Mm-hmm. So I'm just wondering about how somebody benefited and why they decided to go that route when it's something that's simple for somebody to design around.
I mean, maybe that's a good question. And maybe we think it's something easy to design around. I'm not sure how busy this field really is, but if somebody, again, Bhupinder kind of touched on this, if somebody thinks that there's a commercial value in being able to get a patent for something like this, and then be able to enforce it or force your competitors to come and get license from you, if that's kind of your understanding of the competitive field or your competition or other businesses in that field, then you would likely get a patent protection for something like that, because the hindsight is, I mean, this is not something you can hide as a trade secret, right? Or the flip side, rather, I meant to say, is that you can hide this brace as a trade secret. So once people see it, it's going to be out there. And
right.
If you haven't protected it, then anybody is free to use it. So if you protect it, I mean, people are forced now to and you successfully get a patent for it, you're forced now, people are forced to come and license it from you. And it's fine if they easily work around it, because now for them to be able to practice that workaround or practice any improvements over that brace, they still have to come and negotiate a license with you if their product itself uses something that you have claimed. Do you know what I mean? So this is, there are two different things happening. If for you to be able to practice your own invention, or for somebody to be able to sell their products, they still have to make sure that they're not infringing on other people's products or other people's patents. And so filing for patent protection could be one way of forcing any improvement products coming down the pipeline to force a license or negotiation with you to be able to practice their invention. Does that help?
The thing is, like, what I noticed, and I'm using this as an example because I once upon a time had to go get one of these braces, and I noticed that product, there was so many different brands available that each had their own registered patented design.
Right.
And so I just, I'm using that as an example, and that's the thing that's in the back of my head when I'm assessing something that I've come up with that has a specific utility, and I've come up with a design, a basic design to utilize or apply an approach to get a benefit from using this mechanical device. But once it's out there, there's so many different ways to design something that could still implement or apply that same process.
So that's a good question, actually. And this is something that I hopefully answers your question. But my point here is the patent agents or patent lawyers that are going to help you with your patent application process are hopefully going to take care of this problem. Because when we try to file for patent protection for an invention such as a brace, it's not about that specific design of your brace. It's about the underlying functionality of that brace, and a good, well-drafted patent application will take into consideration multiple embodiments or multiple different ways of securing or protecting this brace concept, which can then prevent somebody else to come and design around it. So the patents can, if drafted well, give you a very broad protection over a particular field, provided that you obviously meet the other criteria of novelty and inventiveness and things like that. But the goal will be to think about how your competitors can design around your invention, in this case a brace, and try and protect it in your patent application today. So it's already.
We're going to touch on some of that strategy in a minute when we go through this example. But I'm very familiar with knee braces because I used many of them over the last 5 years.
But it's not a knee brace. But I'm just thinking of something close to the same kind of challenge that I'm facing.
Right. So usually, the inventions are often very subtle. Most things that are patented are very slight improvements over what already existed. The question is, do they merit that commercial value test to say, is this something that I can maintain price margins? So when you go to buy a brace, why doesn't a brace, which is 2 or 3 pieces of neoprene and a little bit of Velcro, why doesn't it cost $8? It costs $48, or at least 28, right? And what they're doing, and especially the major companies, are maintaining that price differentiation by having small features. And so I honestly broke my leg a few years ago, and I must have bought 10 knee braces over the years, from as cheap as $100 to $2,500. And depending on what I'm doing, when I'm skiing, I use the super expensive one. But the rest of the time, that thing is bulky and irritating. And the rest of the time, I use different ones. And they each have their own benefits and disadvantages. And that's what the companies are trying to protect. There's also a marketing aspect of patents. And it's not at all legal, but consumers will pay more for a patented product. A small company that's just trying to break into the market will avoid typically something that is patented because they don't want to get sued right out of the gate. They just don't have the revenue or the money to withstand that. Usually, if it's a small company that copies a feature, a letter followed by a statement of claim shuts them down right away because they can't even respond to that. But you have to have the legal basis to do it.
Yeah, so the flip side to that.
There are a lot of subtleties to these things, yeah.
Yeah, sorry, I didn't mean to cut you off. The flip side to that is, as a startup, right? you don't have the funds to go after these people either, right? To pursue litigation.
Yeah. But that happens down the road. And you can often, if you have valuable technology, you go down the road before you really enforce. What I often tell people when it comes to pricing decisions about patents, you get what you pay for, right? People talk about provisionals, and they file these very simplified applications, and they get very narrow scope of protection. They then go disclose their invention, and it's not really protected. When you have a good medium-sized tech company, the cost of a good patent program is typically less than the cost of an engineer per year. And you could be filing 8 or 10 patent applications a year and have a very thorough patent program with that. That's actually way more than most companies should spend. So there's a balance between where you make the investment, right? Like it's easy to make the investment in something that you immediately see. And I always tell people, don't buy more IP than you need, but don't buy less either. Like make sure you have a good sales team, you have a good development team, but the value that they're creating, make sure you're protecting that. So there's this balance. And then in the long run, when it comes to enforcement, you're right. No startup that is funded by angels or funded by, Series A investment is in a position to start patent lawsuits.
Right.
But if they have IP, they're in a position to defend them with something that's aggressive as opposed to just being a defendant. And there are a lot of companies that will help you do that. A lot of companies are looking to buy IP, looking to license IP, looking to monetize lawsuits. So having the asset creates the opportunity.
Thanks.
So what we're going to do next, there are a couple, let me just address some of these questions very quickly. And then we'll go on to this example. So there's this question about shoes that with the red patent leather on the bottom. That is a trademark. And what's the name of the company, Reshika, you'd like to more know?
Louboutin.
Louboutin, yeah, okay. Yeah. So that is an example of something where over time, if you just filed an application for the color red or for the shape of the bottom of a shoe, the sole of a shoe in red, you would get a very weak scope of protection. But over time, in people's minds, an association has built up over that color on the sole of a shoe and a certain class of shoe. I don't know that they have coverage for sneakers or for Crocs or shoes like that. But for high-end shoes, there probably is enough protection that if somebody else who, for example, shows their shoes at fashion shows and on runways, tried to copy that color on the sole of a shoe, they could probably be stopped. And that's an example of taking something that might seem very simple, but in a sense, making it proprietary. And I would say that that is an excellent use of a trademark. One of the beauties of it is if your customer base is oriented towards demonstrating their fashion sense or their wealth by buying these extremely expensive shoes and knowing that everyone who looks at them will know what they are, that trademark is very effective. It is protecting those huge margins. I mean, those shoes cost hundreds and hundreds or thousands of dollars. They do no more for you than shoes you could buy at Walmart, except for the social good, right? The social value. And so that trademark is incredibly valuable because they not only don't do any more functionally than something bought at Walmart, they also don't cost any more to make or to ship or to distribute to stores. They just sell for a much, much higher price. And so now you're protecting these massive margins through the entire supply chain, basically by having created goodwill in red patent leather soles for shoes. Right? So it's an investment and it's a discipline, but companies that pull that off create a lot of value for themselves. Last question on claims. You cannot use words. I don't know how many people have the chat open, but the question is whether you can, in a claim in a patent, add the words by any means. Your claims have to be definite. They have to be something that a person can read with a lot of understanding and help and effort and understand what the scope of the invention is. So if you say by any means, the claim will be invalid because it does not distinctly and clearly define the scope of the invention. It's too broad. So with that, we're going to move on to an example. And our example is for drinking cups, drinking coffee. And we're going to go through a few, we've covered some of these patent concepts in a more practical example. So normally when we do this, we have samples. And when we do it in the room there at YSpace in the big boardroom there, we have the samples and we can put them out on the table and it works really well. So this is the first time we're going to try it in a virtual session. So hopefully it goes well. And the story here, it's a little fictional because the use of materials is not historically correct, but just buy into the history as we present it, and it will help understand some patent concepts. So the story here starts with this basic metal cup. It's a stainless steel cup, and it can be used to drink anything you want, but we're going to talk about coffee or other hot liquids, hot milk, and talk about a few features of this cup. It's a metal cup, so it's very strong. It's nearly indestructible. I can tell you that because I still have the one that I had in India 45, 50 years ago. And it's basically the same shape. A lot of scratches, but same structure. It's tapered. It can be stacked, so it doesn't take up a lot of space. Its tapering also allows it to be easily held so it doesn't fall through your fingers. But it has some problems, right? If you're going to drink hot milk in it, there's very high heat conduction, so you'll burn your fingers. And in the modern world, it's not microwavable. You'd have to heat your milk or your coffee up if you're going to microwave it. I know that's a crime to coffee drinkers, but if you're going to heat whatever it is up in the microwave, you'd have to do it in some other material and then put it into this metal cup that's indestructible. So that's our starting point. It's not patented. It just exists out there. And historically, that's what's existed. So that was Allison's cup. And now we come to some innovators who are going to solve some problems. So in the year 2000, my friend Belinda comes up with an idea. She does not want her fingers burned by her hot coffee through her metal cup anymore. She decides to solve the problem by adding an offset handle. So this cup has certain features. It continues to have the benefit of strength because it's metal. She's added a metal handle. In this case, she's attached it with 2 rivets. It's straight, so it doesn't stack, so it takes up a lot more space. It still has some disadvantages that you can see there. Its manufacturing is more expensive because it's 2-piece construction. But Belinda wants to commercialize this product. What she doesn't want is Allison to look at it and say, hey, I already have a market. I sell millions of these metal cups. I will just add handles to my cups, right? I already have a manufacturing facility. I have supply chains. I have retailers. I will take this idea as soon as it hits the market. Allison's not particularly creative, obviously, but she has a great business because she had the only product around. Belinda comes up with an idea, Allison steals it, and she's all set, right? So Belinda wants to avoid that. She goes after a patent. And so on the right side there, we've written up a couple of representative claims. One is for a product, and we say a drinking cup. So the part that's not highlighted just describes a cup. It's got a base, and that base can be used to put the cup on a surface. And then it's got a sidewall that extends up from the base, and the base and the sidewall work together to define a chamber where you can hold a liquid. That's not innovative, because Allison's cup did that too. The innovation here is in the bold and underlined part, where there's a handle attached or connected to the sidewall. That didn't exist in the prior art. And the patent office, let's assume they would grant this patent. They do their patent search and they grant the patent. So now Belinda has a patent for this product. In addition, Belinda in her patent application files a claim for the method of making a cup. She doesn't need to get into the details of the underlying cup because that exists and people know how to make those. So she says providing a drinking cup where it has the structure, and then says mounting a handle to the sidewall. Her patent application is going to have a lot of description. It's going to have drawings that show the various steps in carrying out this method, and it's going to show the final product that's claimed there. So the benefit is that it protects your hands from heat. There could have been some other stuff, the 2-piece assembly and so on, but and there probably are many dependent claims covering those other aspects. But let's think about what Belinda has as an IP asset. She can't stop anyone from selling Allison's cup. That's already in the prior art, and there was no patent for it. So anybody can make and sell these cups. Allison just happens to be very successful in doing so. What Belinda can do is start making those cups and selling them with handles. And in our fictional environment here, she's the only person that can do so. So to the extent that the marketplace wants cups with handles, Belinda controls that market. She can become a sole supplier and put that into the marketplace and try to make her money off that. She can license other people to do it. Maybe she's not particularly keen on having a manufacturing facility, and she might try to license Allison. And because she's the only person with a patent for this, to the extent that there's consumer demand for it, and she'll have to work hard to create that consumer demand, she will probably be able to extract a fairly large part of the rent there. So if a cup without a handle sells for $10 and a cup with a handle sells for $15, how that $5 gets divvied up will depend largely on who controls the IP around it. Well, Belinda is the only show in town if you want cups that don't burn your hands at this point. And so she will probably be able to take a disproportionate amount of that $5 margin that a consumer is willing to pay for this feature. So as time goes by, other people want to get into this market as they start to solve the problem differently. So ceramics come along. So Chris, in the year 2002, says, I don't need handles on the cups. I just need a material that has a much lower conductivity for heat. So he comes up with a ceramic cup. It has thicker walls. The material is inherently less conductive, less heat conductive. And it's tapered, so it can be stacked, and maybe not as stackable as the original, the Allison metal cup, but it has a lot of those benefits. It has some disadvantages. It's fragile. It's more fragile anyway. But Chris sees an opportunity to get into this market of coffee cups, and he patents his idea. Now, if you just look at this cup, can Allison stop him from selling it? No, because she doesn't have any IP. Can Belinda stop him from selling it? No, because Belinda only has effectively a patent for handles on cups. He doesn't have a handle. So Chris can make and sell this product without getting any IP protection whatsoever. The problem is other people will get into the market. So he decides to pursue a patent, and he ends up getting a patent, and he essentially describes the same cup base with a sidewall that extends up to define a chamber for holding liquids. And then he says the base and the sidewall are formed of a ceramic material. He can be quite broad. He's the first person to use a ceramic material. If he knew about other materials, he might define it in terms of its heat conductivity. There are other ways to get around the question of what is the specific material, because you might, for example, have some sort of polymeric material that is not ceramic that achieves the same benefits, and so on. To the extent that Chris understands the range of materials, he wants to choose the words so that they're broader. So this claim stands as an example of where you might have made a mistake. You say a ceramic material, but there are a lot of very functional materials that are not ceramic that'll do this just great. In fact, many of the cups you buy now are plastic of some kind, and they're just as good. So we talked earlier in that example about the brace, about getting patents that are too narrow and people can design around them. You have to put a lot of effort into choosing the words, because every one of them will be picked apart. And we spend a lot of time on what do the words mean. In a US case, there's an entire hearing process that I'm enmeshed in one case right now, actually in two cases right now, where briefs go back and forth, documents go back and forth for months. And then there's a full-on hearing that can take an entire day, sometimes even longer, just to determine what 8 or 10 words of the claims mean. So the selection of terminology defines the scope of the claims, and it is key to your ultimate success. So Chris gets his patent, and he can stop people from selling ceramic cups that stack and that are tapered and so on, and don't burn people's hands. And if you look at the method claim there, he doesn't just say, well, make a ceramic cup. You have to provide more information than that. So the method, if you're going to make a ceramic product, is typically you're going to use a mold. So if you're going to do it in a commercial sense, you can't have people sitting there with a spinning wheel, making each one of these things individually. If you're going to make them in commercial quantities, you want to do it in a mold, using a mold. So you form the mold, and then you follow the process. You fill the mold, you fire the mold, you apply the glaze, and you fire the glazed cup, and then you end up with a commercial product. So your claim really only has one inventive aspect to it, that a ceramic material was used, but it would probably hold up in this in this fictional environment. So what does he have? He has an alternate solution to the metal cup with a handle. And so now there are two competitors that can legitimately keep your hands from burning. Belinda has competition. They can coexist. Some people will like one, some people will like both or the other. Many people will buy both. They don't need to, there's no real barrier between them because they have completely different innovations. This one might have some advantages, and Chris might sell in his marketing, say, hey, not only doesn't it burn your hands, it keeps your coffee hot much longer than a metal cup, which radiates all the heat out. It has the advantage of single piece construction. And he's going to use all of those things in subtle or obvious ways in his marketing and his development of his business. So then, much later, in the year 2015, I don't know why I took this long, but maybe ceramics are hard. And the next innovation, Dave comes up with the idea of saying, well, I can have an integral ceramic handle. It's not riveted on, because ceramics behave differently and you can't drill holes through them and rivet things onto them and have them sealed. So Dave comes up with this cup, which is a lot like Belinda's cup. And it's made of ceramics, so it's something like Chris's cup. So now he gets a patent. And he describes your basic sidewall and horizontal basin sidewall. And he says he's got a handle connected sidewall. So right here, up to this point, that's Belinda's patent claim, right? And he says, instead of saying it's made of a ceramic material, he says the base, the sidewall, and the handle are integrally formed. So this will cover multiple materials. It's not limited to ceramics. As long as there is a handle and the handle is formed in an integrated process with the base and the sidewall, this claim will cover it. Now we get to a little bit of a battle about what happens in the marketplace. And then people feel free to speak up in the chat, but the question is, can Dave sell this product in the market in 2015? We know that Belinda has a patent from 2000. So let's go back to Belinda's patent. She says that there is a cup with a handle connected to the sidewall. Well, Dave has a cup with a handle connected to the sidewall. It doesn't matter whether it was made integrally or not. Belinda didn't say. It just says that the product put into commerce has a handle connected to the sidewall. That claim is infringed by Dave's product. So Dave can't sell that without Belinda having something to say about it. If you look at Belinda's method claim, it says providing the drinking cup and then mounting a handle to the sidewall. So that is not necessarily infringed. It probably isn't infringed because Dave formed them integrally. He didn't first provide a cup and then add a handle. He did them in one molding or processing step. And there are molds that can do that. They're more complicated molds, but they can definitely do that. So Dave infringes Belinda's product claim, but not necessarily her process claim. If you look at Chris's claim, he says that there's a cup, a base, and a sidewall formed of a ceramic material. Well, Dave definitely infringes that as well. The fact that he has a handle is an additional feature, but the underlying cup still infringes. So now he's got a problem with Chris as well. And I grew up with these guys, and they always had problems with each other. So all of these are people that I grew up with, all the names. So he's got a problem with Chris's product claim. Now look at the method claim. Same thing. Chris, to the extent that it uses a mold-based and glaze-based process to make a ceramic cup, he infringes the method claim as well because he's using a ceramic material. The fact that he has a handle, it doesn't change the fact that he's infringing. Having a product with more features, as Reshika said, having a patent does not give you the right to do anything. It doesn't give you the right to infringe someone else's patent. That underlying right exists, and because a patent is a negative right, the previous patent owners can enforce their rights to prevent you from using your innovation. So what does Dave do? And the reason we chose these years, there's a mistake here. Okay, so what does Dave do? He has some choices. And the other people have to think about some things. Belinda got her patent in the year 2000. It expires in 2020. So while she may be able to corner the market on some part of the commercial space there, her time period is coming to an end. Same with Chris. He got his patent in 2002. His patent is going to expire in 2022. Dave has some choices. This should say 2025. It says 1925, but it should say 2025. So Dave has some choices. He can wait it out and until Belinda's patent expires. He might have to wait it out until Chris's patent expires. He might go get a license. He might license this back to them because they're already in the market. They already make products. They already have supply chains. They already have a distribution network. They have a retailer network. They might want to take on this new product. And the negotiation will be, well, when, during the time when all the patents are enforced between, this was 2015, so 2015 to 2020, there are a number of rights in place. And there is a different pricing and sharing of the benefit that might happen until 2020 when the first patent expires, and in 2022 when the second patent expires, at which point Dave might have the upper hand and be able to use his patent to extract more value out of the licensing relationship. And that's all up to negotiation. You can negotiate anything, but if Dave wants to, in the short term, benefit from his innovation, he will have to deal with those previous innovators. What actually happens depends on a lot of other things, whether one of them is more particularly suited towards the commercial aspect of it, not just the innovation, whether they're still interested. And what often happens at this point, especially if these are very small companies, is that the earlier innovators actually sell their business to the new guy. And they want out, they want to monetize, they want to retire, they want to focus on something else. So any one of those things is possible, but these three innovators will have to deal with each other. Belinda and Chris coexisted, but Dave can't coexist with either one of them. And by the way, licensing, I've always thought of it as the holy grail of IP. Because when you license out, what you do is have someone else do all the hard work, all the manufacturing and the commercialization. You just get a piece of the pie. You don't generally get a huge piece of the pie, but your costs are also very low. But very successful licensing companies, they mostly have salespeople and accountants working for them. So it can be quite profitable. It's hard to pull off, but it can be quite profitable. And so I always mention that Dave doesn't have to do any of this, marketing, manufacturing, distribution, if he can build a good licensing program. So let's keep going. In the year 2020, two things happen. Belinda's patent expires. And Effie comes along with a transparent glass cup with a handle. So now Belinda's patent is expired. Effie doesn't have to worry about that patent, which talked about offset handle. Chris's patent only covers ceramics. Glass is not a ceramic material. Dave has a patent that's not limited to ceramics. It covers a cup, a base, a sidewall, and a handle that are integrally formed. So, does Effie's cup infringe? It will depend on how she makes it. So you could make this product in two steps and make the cup, make the handle, and join them. So they at one point were not integrally formed, but after they're formed and they're put into commerce, are they integral? This is the kind of debate that happens in court a lot. If I had Dave's claim and Effie started selling this cup, I would sue Effie for sure. There's no way I would let it go on the basis that, oh, theoretically they were not integrally formed. I'll say the entire forming process, it started whenever you started making the cup, and it ended when you had a finished product. And now you have an integrally formed cup and handle. We'll have to debate that and figure out what the courts have to say about it. Most likely we'll settle our lawsuit on some licensing basis or some payment. But as long as Dave is a sophisticated person that has the financial and business wherewithal, he's not going to let this go just because he sends a letter and Effie responds, well, they're not integrally formed. That letter is not going to solve the problem. It's going to take a lot more than that. So now, last time we talked about, well, there are a few years left in the patents, 5 or 7, and that's not a few, that's a long time in high tech anyway. But in this case, there's 15 years left in Dave's patent. And even if Effie waited it out, she'd only have 5 left of her own. So she has to deal with him. If she wants certainty, she could go up to him earlier and try to deal with it from a position where she's not already in the market and threatened. I'm not going to say that's weaker or stronger. That depends on the circumstances. But ultimately, she's got to go back to Dave, or Dave will come to her. But they're not going to be able to coexist without some sort of arrangement between them. So technology moves along, and now Sarah comes along, and she comes up with a glass cup. This is happening in 2021. Belinda's patent is completely expired. Chris's patent is still in place for another year. Belinda has a metal handle that attaches to the bottom of the cup, to the base. And she gets a patent for it, and it's for a cup that is a handle that is removably connected to the base. is certainly not integrally formed because it's clearly removable. When the handle is removed, the cup stacks. It's got various benefits. It's not a ceramic material. And the when Belinda, oh sorry, this is Farah. When Farah went and got her patent, she talked to her patent attorney, and even though the product she came with has the handle removably connected to the base, it's debatable whether it always has to be connected to the base. What if it just had a wider diameter and it connected somewhere up the sidewall? So this is an example of thinking through what will other people do to get around your patent. If you only had the handle connected to the base, then the other part of our business at Bereskin Parr is to help our clients avoid patent infringement. If somebody presented that first claim to me, I would say, well, that's fine. Don't worry about it. Just make a part of the sidewall so that it will be able to, in some kind of interference fit, be able to accept a handle. Just move the handle up. No problem. It's solved. And you're not connecting it to the base. So again, now we're going to get into a debate about whether it's directly or indirectly connected to the base. But the better thing is for Farah to get a patent that covers both alternatives. And she doesn't have to sell both, she doesn't have to make both, but she wants to keep the market from having an alternative to her product in it, which will eat away at her margins. So now she's got to think about, well, how am I going to commercialize this? Let's go back to some of the other claims here. Let's go back to Chris's patent. So, sorry. Let's go back to Belinda. When all it says is a cup with a handle connected to the sidewall, mounting a handle to the sidewall. Well, some versions may only be connected to the base. Some versions may be connected to the sidewall in the marketplace. There's the question of whether this is directly or indirectly connected to the sidewall. There's a question of whether the sidewall extends all the way down to the base. Is the base only the inner part that is directly under the liquid holding cavity, or does it extend to the edges? All of those things are debatable, but Farah doesn't have to worry about it because Belinda's patent's expired. Let's go back to Chris. He's got a year left. And she's good on this one because it's not a ceramic material. She's good on Dave because they're not integrally formed. They're clearly detachable. Now, Effie's claim was only for a transparent glass sidewall and a handle connected to the sidewall. So she is in a position to potentially come after Farah, right? But for the same reason I said, where does the sidewall end? Where does the base begin? And those are the kinds of things that are thought about in patent litigations all the time. Some other reasonably important things to think about when you're doing this. Now, is this just a trinket? Will the market really buy this product? I did buy this product. I have a whole bunch in my office just for this demo. And it works okay, but it'll, like if you tip it too far, the glass will pop out of the handle. So it's not a great product. It's okay. It's a good little novelty. But if it's just going to have a fad presentation in the market, existence in the market, you don't necessarily want to spend the money on the patent. You might just push it as hard as you can and see what happens. If you expect it to be there for years, then you might want to pursue a patent. So with this one, you're starting to get into a more complex analysis of, do I even want to enter the market? Can I get margins that make sense for me to be in this marketplace? So next is the last one. And now we're solving the problem in a completely different manner. Is this 2030? Most of the patents have expired. Sorry, the first two patents have expired. Dave, Effie, and Farah still have their patents in place. But let's look at the features. So we have a transparent glass tumbler. It's a double wall tumbler. It should have some sort of inert gas inside between the walls. It could be vented. A lot of them are vented so that they don't crack too easily. Some of them are pressurized. You get a lot of different variations of this product. This is a very premium product. It costs a lot to make. In order to make it, if you look at the method claim, the only practical way to make a product like this is with a rotational mold. You can't do it in a simple mold at all. And so the cost of manufacturing is much higher. The temperatures required to do this and the temperature controls required to do it are much more precise. Does this product infringe any of the previous patents. Well, it doesn't have a handle, so it doesn't infringe any of those. It's not ceramic. It doesn't infringe any of that. Basically, this one can go forward. It doesn't infringe any of the patents that are still in force. The question is there a market for it? So that's something that the innovator has to come up with. A lot of innovations are great, but they don't solve a problem that a lot of people have. You only want to patent things that other people will actually want to make. It's a negative right. You can stop other people from doing something. If nobody cares about doing it, then there's really nobody to stop, and the patent doesn't have any value. So in this case, Gina decides that she's going to go after the patents for this. She's going to sell it at a premium, and she starts to patent a double wall cup where the inner wall defines the liquid holding chamber. There's a space between the inner and the outer walls. And then she starts to, in these dependent claims, talk about different alternatives. So the first claim is quite broad. It just needs two inner and outer walls. The second claim anticipates the idea that somebody could argue that a thick material has an inner wall and an outer wall, and between them, they have some other material. They are not spaced apart in the sense that there is definitely a gap between them. Maybe they're spaced apart or they're filled with something else. So claim 2 is a little narrower. It says that they're clearly spaced apart, but that doesn't say that they are enclosed. If you just made a cup where you had an inner and outer wall, but they were open on the bottom, you would actually have a lot more heat leakage than if you sealed the bottom using the outer wall. So claim 3 talks about having an enclosed insulating chamber between the inner and the outer wall. So now you have something that will keep your coffee hot much longer, probably even much longer than a ceramic cup. So claim 4 gets to, well, it's substantially evacuated of gas so that there's no material that can radiate heat between the inner and the outer walls. Conduct heat between the inner and the outer walls. You would only have a radiant transfer, which is much, much slower. So we have an example of a product that can evolve. It can start off as a simpler product, maybe in the scope of claim 1, and over the years of this patent and over the years of this product, have additional features, and they're all built into this original patent. And then the last one is the method of using a rotational mold to make the cup. So the IP here, I think if you were actually able to do this and in this fictional story, would actually be quite strong, assuming that all the prior art is only the 5 things that we showed you before. And the question, of course, is really, can you sell this at a reasonable price? So if you go buy one of these things, they cost about 3 times the price of a normal glass cup. Starbucks sells them. Starbucks has sold them. I haven't seen them, or I haven't seen any Starbucks recently, but even before this COVID-19 thing, I hadn't seen them in quite a while. So, it's a product that comes and goes because of its price. It sometimes appeals to consumers and sometimes doesn't. But that aspect of it, that pricing and market, gets into, well, where might I patent this? So if you have a premium product, you're not going to sell it in countries where premium products don't sell well. You're going to typically sell it in Europe or the US or Canada. And so we often tell people, go with the English set of countries where there's high margins for these kinds of products and there's a fairly high take-up of them. If you want to do continental representation, people will file in Brazil or South Africa, China, Japan, Korea for Asia, sometimes in India, depending on the product. So that's another approach. I don't really like that approach very much. I think you need to have a little bit more of an understanding of your product line and where it's really likely to be successful. Sometimes people say, well, my product's going to be successful everywhere, and we'll look at this regional approach, but that generally doesn't actually hold true in the end. In making the decision about where to file and where to invest in IP, where are you going to manufacture? No matter what, this product is probably not going to be manufactured in Canada or the US. It's going to be manufactured somewhere else. It could be Mexico. It could be in Asia. And so you want to look at that in terms of where you might patent as well. Look at your infringers. Look at your potential licensees. If you're a Canadian company that can sell in Canada and the US, but you can monetize this in Europe, you might still patent it in key jurisdictions in Europe. And the key jurisdictions in Europe are generally Germany and another country or two, or the UK and another country or two. The UK, because it's a fairly easy, very accessible market for Canadians, and Germany, because patent enforcement is much easier in Germany than in most other countries. So through this story, and usually we have a lot of back and forth, and we kind of have people propose potential claims as we go through this. Through the story, I think it's an example of a very simple product, but as innovations occur, there are things that can be protected, and those aspects can often lead to the difference between a product that is commercially viable because it can maintain a reasonable price, and products that are totally not viable at all because the companies are already in the market can immediately adopt your features. And so they have so much advantage of already being in the marketplace that there's almost no way to enter that market. That's the end of that example. Does anyone have any questions about it? So one question, what is your recommended strategy for writing patent claims? Simpler the better, focus on one unique feature, describe all the options. So it's really situational. Every case has different driving factors. Every client has different objectives. And what we find is that if you try to apply like a cookbook or a flow chart to this, you'll end up with patents that don't serve your needs. And if you look at this last set of claims that's on the screen, we're starting to demonstrate the benefit of thinking in layers. Think broadly and then narrow the invention according to different features and aspects that might have commercial value. But we write claims that are very long, that are very narrow, but we know that they have value in that industry, especially in very, very competitive industries and consumer products industries. I do a lot of work in the absorbent articles business, and people will file patents for minute, tiny, tiny inventions, but they sell billions of those products every year. So there's margins, there's a margin in there. And if they're getting, 1 penny, well, a billion pennies is, it's a lot of money. It's $10 million. So there can be a real benefit to even very narrow patents. In some cases, your narrow feature doesn't really matter to the consumer. They'll buy either one, and a small price difference will lead them to buy the one without the feature. That patent's not worth very much. So your claims really have to be based on the commercial reality, the technical reality about what was really invented, and also the commercial reality of what can really be claimed here. So Steve asks, can patents have multiple unique claims or just one primary claim with multiple variants? Okay, Reshika, do you want to get that one?
Yeah. So yes, you can have multiple claims. In fact, just on the screen right now, you see 2 independent claims, claim 1 and 6. And each one of these claims will then have dependencies that will further narrow the scope of protection you're seeking. Typically, the independent claims in your application, if it's a high-tech invention, you look at system and method claims. Those are commonly included, or an apparatus claim. And those independent claims are sort of the broadest monopoly that you're seeking. And then with every dependent claim, you try and narrow the features. And
right, and then
yeah.
And I'll just go back a couple of pages. So this is an example of having, in Europe, typically you're only allowed to have one claim of a type. So here we have the apparatus claim for the drinking cup, and we have a method claim. They have to be related to the same invention. There are some exceptions in Europe, but in general, they'll say you can't have a second claim for the cup. You have to combine all of those into one set. But here's a set, and this is very common in Canada and the US, where you have multiple claims directed to the same type, the product itself. And so in Canada, the US is very common to have, especially in Canada, because there's no limit on the claims. There's no claim fee for going past any particular number. So we've obtained patents with hundreds of claims in them. In the US, there's a fee for going past 20, and at some point, it doesn't make sense to carry on. It makes sense to just have 2 patents.
Steve has another question. Can patents have multiple unique claims or just one primary claim with multiple variants? Okay, that's been answered. If inventing an electrical product, should I use a patent attorney that has deep knowledge on electrical technology? I would say yes. It is beneficial to you to hire somebody who has that technical background. primarily because then you're not spending a lot of time training them and getting them up to speed. People with engineering backgrounds are likely familiar with at least the general concepts that are going into your electrical products, and any teaching that you have to do is hopefully not too much, and that saves you time and money. You know, it's more cost effective.
So when you go to license or enforce your patent, if you're in litigation, the claims, there will be a process in which the scope of the claims is determined. And so that's called the construction of the claims. And the general rule is that, and there are a lot of contradictory rules, so here are a few of them. The patent owner, the patent applicant, is entitled to be his own lexicographer. You can take any term you want and define it in a dictionary sense in your patent application. So, you know, you can make up words if you want, Google, and define them to mean anything you want. And so while that's permitted, it's really not advised. So that's one principle. But you have to be very clear about the meaning of those terms. The next one is terms in the claims will be given their ordinary meaning. And so that's completely contradictory to the first one. So you haven't clearly defined your unusual or special meaning, then your claim will be given its ordinary meaning. And in the context of that field, as read and understood by a person of skill in that technology, and in the context of the entire document that you filed, and taking into account all of the submissions that you made to the patent office in order to get your patent. So if you're working with someone who doesn't know the terminology, there is a very high likelihood they're going to use unusual language that ultimately is going to come back to haunt you. And I would definitely avoid jack of all trades patent attorneys. You are basically doomed if you go down that road. In our firm, I don't do any life sciences work. The closest we get is to do AI and analytics around data that relates to life sciences, but we do a lot of specialization. So when we hired Reshika, we were looking for an electrical engineer who understood electronics and electrical stuff and computers, and understood software and the confluence of all that with mechanical systems and controls. But I would never ask her to do like a molecule patent. And, you know, I'm working, one of my clients is a chiropractor and he's developing a CBD product. I didn't write that patent application. I brought someone in from our life sciences department to do that. So it is very important that you hire people to do the work who are suited to doing it. And just on that point, if your patent attorney takes what you give them, reformats it, patentizes it, writes an application and files it, you're not getting your money's worth. There should be a detailed discussion about what the scope of the invention is, what competitors are doing, how you might commercialize this, what your second and third generation products might look like, what your rejected ideas were, because you might have chosen the one that you think is best, and you might be right, you might not be right, and you may end up commercializing one of those alternatives over time. If you're right, one of your competitors might want to commercialize one of those alternatives that's pretty close, has most of the benefit, but doesn't infringe your patent. Your patent application should cover as many of those alternatives as possible. So if you're not having that conversation with your patent attorney, then you are ending up with a patent that is still going to cost a lot, if it's any good at all, but doesn't actually have the scope of coverage that you could have gotten. So not only people that have the right technical background, but people that take a very practical and commercial approach to getting valuable rights. I think that's actually all the questions. So does anyone else have any questions?
Can I ask a quick question?
Yeah, go for
Sure,
it.
of course.
Sorry, just one quick question. So just to use an example of, are you familiar with foam rollers used by people that run in the gym? So if the first person that came up with that design, is that something that you would suggest is a patentable product or design?
So things like that can be a little difficult because there's going to be a lot of prior art. So even if, for example, you're the first person to come up with the use of like a cushioned roll to I guess to massage muscles or to manipulate your muscles, you would have to do a search to see if, first of all, the product exists per se, and it probably does in some form or another. Even if someone, for example, took a rolling pin and used that to massage their leg, that's a roller. I don't know whether it's a foam roller. And then whether that process, that, maybe that therapeutic process has been done in the past. So you have to do it in the context of that search and analysis and decide what to patent. In many cases, what will happen there in that conversation is the basic idea of just having a roller, or even a roller with some sort of deformable or cushioned or foam outer layer, may not be something you can patent immediately. But what we often tell people is think about your products as you move down the road here. If you want to get into the market very quick and easy, you might sell a simple product that's not patented even, or not clearly patented. But then you quickly, in the next year or two, move to products that have greater features. So they have patterning on them, bumps on them, they have different regions on them for different uses. And that is what you end up patenting. And then what you want to do is move your customer base to favor that product. So you try to align your IP strategy with a business strategy where you can make more money by selling that premium product at a margin and keeping your customers and your competitors under control. So products like that, those very, very simple consumer products are very challenging. And usually what we recommend is that you do a thorough search. Like before you go see a patent attorney, because a search is going to cost you $3,500, $4,000, $5,000. It's a simple product. You can do a keyword search on Google Patents just like anybody else. There is a bit of an art to it, but don't go and spend $5,000 to have somebody show you a patent you could have found in 10 minutes. So do that searching up front. And then when it comes down to your long-term commercial strategy, in that prior art context, in the practical business product analysis, see what you can patent. And so we have a lot of clients whose initial products are not covered by their patents at all. It's their future products that they're protecting. And they file those applications early on. It keeps their investors happy, but also they don't wait to file them, or at least they don't wait a long time to file them, because their competitors will also see new products in the marketplace and think about alternatives and improvements and be patenting. And so you want to get your applications on file early.
Thanks very much.
I think a couple more questions have just popped up. So this one, I think is copyright related. So Bhupinder, if you had an original work with creativity, for example, on a poster that has a unique feature within the works, to protect it, would it fall under a trademark or a copyright? And when would the timeline be with introducing it commercially once you start the process? And it goes on to say, meaning, should it happen after the process of protection is finished, or can it start at any point of process and still be protected? Once finished with the process, yeah, go ahead.
Yeah, so yeah, they're fairly different rights. The trademark, you should register it, and you can actually start using a trademark before you file the application. The date of first use in commerce can be the critical date, and the date of filing the application can be the critical date, whichever one happens first. The date of filing is pretty much crystal clear because you get an application date. The date of first use in commerce can be a little bit unclear, and if you start using a trademark in commerce and someone else starts using a similar trademark, that can actually keep you from being able to register it. So in terms of when you can file and when you can't file, trademarks are very different from patents. You can file a long time after you start using a trademark. The longer you wait, the more risk there is around not being able to protect that trademark. But sometimes you're forced into that position, especially if you have a distinguishing guise or a 3D trademark or a scent or a smell or some other non-traditional trademark. In terms of the relationship between trademark and copyright, trademark exists based on that connection, that distinctive aspect in the mind of the relevant consumer marketplace between the trademark and the source of the product or service. So that's a fairly legal question. Copyright exists just because you've created something. So pretty much anything that you create that has any meaningful creativity to it has copyright protection in it, regardless of whether it is a trademark. Now, the enforcement, of course, is very different too. With copyright, you have to prove copying. With trademark, you have to prove that the person's use of their trademark damages you in commerce. It confuses your potential consumers, that it is being passed off, it's diminishing the value of your brand. There are different things that need to be proved. The rights are different. The claim to damages is different. The quantum of damages is usually very different. The intention of the user can also be different, the intention of the infringer. And trademarks intention does matter for common law trademarks. For copyright, it has to be intentional, basically. It has to be copying.
There's another question from Steve. Do patent writing attorneys typically defend in litigation, or is litigation a special skill? I had one patent that we had to sue an infringer, and it required a whole new attorney. I wish that the patent prosecutor, I suppose, knew the litigation process.
So this is an interesting one, because before Reshika went mat leave, we were working on litigation that's still going on. But most of the work that we get involved with is in the US. And what our experience is that there is a skill to litigation, of course. There's that skill of, first of all, just the knowledge of the court's procedure, the timing, the paperwork, knowing how the judges behave. And we try to hire attorneys who are very familiar with the courts in which a lot of patent cases are heard. So there is definitely a skill to that. And the people that we hire are always engineers. They're engineers who have done some patent work and gone on to do litigation. I don't generally hire people to do litigation who are jacks of all trades, because I need an expert. And what we bring to the table in those relationships is the technology side. So we try to put together a team of very strong litigation talent with people who understand the technology, understand the client's business, and that team collectively does the work. In a real litigation, if something is going to be fought about, you're going to need a bunch of people, and you're going to need both sides of that coin. But you don't want to sell either side short. When I see litigators try to do complex technology on their own, they struggle, because how are they going to depose an engineer or a PhD scientist or a researcher when they have a passing familiarity that they've picked up in the course of this litigation over the 6 or 8 or 12 months since they got the file, while they have 10 other files? That's not realistic. And then on the other hand, you don't want someone just focused on the technology. You want someone who understands the strategies and how you get the judge, and in the US, a jury, to agree with you. And one thing to remember about the legal system, the courts are not a justice system in the commercial sense. The criminal justice system is meant to be a justice system. But the civil courts aren't there to figure out who deserves to win. There's a little bit of an aspect of that. What they're there to say is, on the balance of probabilities, who's probably right here? And conveying that to the judge and the jury is a real talent. And so we've hired people that are like $1,200 US an hour, because we want to win. And we bring that talent to the table. So when and Reshika and I have been through a couple of litigations in the US, we hire top-notch, grade A, uber expensive litigators, because that's what we want to do. That's what the client wants, is he wants to win. And so you got to have that skill and talent at the table if you're going to win.
Yeah, 100%. And I think people who choose to pursue litigation versus prosecution, they tend to have different skill sets.
Different temperaments.
Absolutely. We're the calm ones. When we worked as the experts on the patent, but brought on litigators and have them go to the courts and just working together, keeping each other in check is also a great benefit of that kind of collaboration, I find, because they are, if it's one of the patents that we've drafted that we're trying to enforce in, say, US litigator is going to come and with their own set of smarts and expertise, they can come and question us about why we chose certain claim language or what we did, what our intention is, and to keep us in check. And then we kind of do the same to them when they're trying to understand the technology and go to court and fight the case. So that collaboration actually could work in your benefit, having the experts. Obviously, I mean, there's cost to it. But if you want to win, then that's the way to go.
In fact, I find that it usually lowers the cost quite a bit, because first of all, the Canadian team is usually the technology group, and there's a lot of technology work in a patent case. And the Canadian team is, first of all, billion Canadian dollars. They already understand the technology really well. And part of my job, managing these litigations, is to make sure that my clients' interests are being directly represented. I've known some of these clients. One, I've known them for 20 years. The other one, I had known them when we did this case in 2016. I had been working with them for about 12 years at that point. But you really know their business. And so it's a lot easier for us to represent their commercial interests. We know who their competitors are. We know what their hot buttons are and their risk factors are. And so it does help to have your long-term patent team involved. But personalities are a big factor. And, I would say many patent attorneys who are in the patent procurement business aren't particularly suited to the litigation process. It's critical, like if we drafted patents and when we talk to the US guys in our team, they'll say, well, why do you use this word instead of this word? And it can be quite aggressive, right? But if they don't do that and we don't provide those answers, that same question is going to come from the other side. Exactly. So it's not always the most comfortable experience because your work that you did 12 years ago is now being cross-examined microscopically, but having that team together can be very important. And we're actually in the process of trying to retain US counsel on a new matter. And we've actually got to deal with a guy to do it on a partial contingency. And one of the things he said was he'll only do it if the original prosecution team is involved in the process, because he wants to know why they made decisions over the life of that patent family.
Yeah, no, it makes sense. There's another question from Steve. Do you normally document the logic in writing each claim for patents you write in prep for a future litigation? It could be very difficult to recall the logic years after.
Not particularly. And we do in our notes, in our conversations with clients, what we produce, the paperwork that we produce is privileged. And so it's fine to do that. So we might have high level notes about it, but the reality is that whatever logic you think you have when you're drafting the claims will usually go out the window when the infringer shows up. And like I said, it's a decision-making system. And the objective is to get the decision maker, the judge or the jury, to agree with you. Usually your position and your story that day is going to be different than the one you might have told on day one. The circumstances are different. The market has evolved. Usually years have gone by from drafting the patent application. So we enforced in 2016, 15 or 16, we enforced a patent we had written in 2003. We're currently enforcing patents that we wrote in 2004. And the market has changed a lot in between. So while we have our original strategy in mind, it's not a question of recalling it. It's more a matter of assembling a rational argument that will win the day when we go to court next September.
Okay, Josh asks a question. So my question is, say I started a company and we are the next Disney or Sony Picture MGM. So how do I protect my work and my images and brand? Some things would be licensed out for TV channel to play or images, but with social media, it allows company to own part of your images or steal and change up or reuse or just share and credit source, but then build brand off my work and I don't get paid. Regarding Twitter, Instagram does build my brand.
Yeah, so that's a bit of a complicated question. I mean, from a purely legal point of view, if you create something, you have copyright in it. There's a copyright question. And you have to enforce your copyright in order to protect it. You don't lose your copyright if you don't enforce it, but you only monetize it through enforcement. What you will find is that large companies, the Disneys, the MGMs, don't infringe copyright intentionally. They're much more interested in buying useful content because they're not in the business of being in court as defendants. They're in court as plaintiffs all the time, but not as defendants. It doesn't serve their interest, and they have a very good understanding of the law. I mean, they have armies of people managing copyrights, and so they're not going to infringe anything intentionally. And if they've bought something or if they've accidentally had someone infringe copyright, they will usually deal with that quickly. If you have a small competitor who just steals your work and reuses it, we actually find that it generally works pretty well to shut them down. Like if you send them a letter and go after them, generally you will achieve a good result from that. Most small companies are not particularly interested in getting sued. If you have someone who just doesn't care, and that does happen, they don't react, they don't respond, they just carry on, that can be a bit of a challenge, and you might have to drag them to court. So one of the challenges in IP and in all areas of law is that there is a cost to enforcement. And sometimes you actually have to go through that enforcement step. If the threat didn't exist, then nobody would follow the rules, or most people wouldn't follow the rules. And so sometimes you have to follow through on the threat. One thing I would suggest is as an owner of IP or as a creator of intellectual assets and property, you should have a very clear system for documenting that. You know, clearly keep track of what you've created, when you created it, who participated, what the agreements were around it, and be able to prove your creation, prove your independence. If you have derived it from something else, know exactly what that was and what you had access to, so you know what belongs to you and what does not. And if you have a good systematic process for recording all of that, then when you do go to court and you're asked, hey, how did you invent this? When did you invent, or when did you create this? You can demonstrate that much more easily. So when you see all these cases, you know, the Ewoks, there was an Ewok case against whoever owned Star Wars. It was before Disney bought it. They lost because they couldn't prove that they created it. They couldn't prove that it was distinctive. It was just another, you know, short black creature with beady red eyes. And there were lots of those in science fiction. So if they had had a better track, a better record of this is the specific design and image that we created. This is the date on which we showed it to the media company. And this was the interaction. And they had contemporaneous records of that. They might have done better. I don't know if they would have done better, but they might have. And there are story after story of small companies, small, you know, individuals going after big media companies for things like that and just getting crushed because they don't have a good way of proving what they created or that the other company ever saw it. So track all that stuff. It's more important in the creative side than it is on the technology side, but you should be doing it on both.
Yeah, on the patent side, I mean, this kind of IP Bible that Bhupinder is talking about, it can help in determining inventorship. You know, sometimes those issues arise where, you know, multiple people have touched the invention, but it's difficult to say who actually did the inventing, who should be the named inventor. So if you have records of who did what at what time, those kind of facts can be helpful to determine inventorship. And I think with that, we have answered all the questions.
Yeah.